Okay,
No, Your
are
Honor.
we all set?
I will get us recording. All right, we're live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to the February 2nd sitting of the Massachusetts Appeals Court. My name is Mary Sullivan. On the panel today will be Justice Gregory Massing and Justice John Englander. Even though we are appearing in a virtual forum, the usual rules will apply. 15 minutes per side of oral argument and no rebuttal. But because we are in a virtual forum, as you can already see, we have from time to time some technical issues. I'm told that my video and my voice are out of sync. We ask only that you be patient with us and we will be patient with you. If there is a technical problem, we will make sure to pause and readjust. We may go black for those of you on YouTube while we do so, but we will come back and we will ensure that everybody is heard. And in addition, if you happen to see any of us look away from the screen, we are not being inattentive. As is always the case during oral argument when we are in person in the courtroom, we look to our notes. In a virtual setting, our notes are on an iPad or on another computer screen, so we may need to turn, but we mean no disrespect. And with that, we will call the first case. That is case number 2020 P0169, Commonwealth versus, is it LOANGO?
Yes, Your Honor.
Okay. Attorney Murphy?
May it please the court. Good morning, Your Honors. My name is Sean Murphy. I have the pleasure of representing Mr. YERMAN LOANGO in this appeal. And I will note, just for the record, that Mr. LOANGO is at least constructively with us as he is watching via stream online. This appeal boils down to the fairness of Mr. LOANGO's trial. The fairness of trial was offended mainly by the admission and reference to other people's fear in this case. I'd like to take this time before this court to focus on issues 1 and 3 of my brief, and of course would be more than welcome to answer any other questions that this court may have. Turning to the first issue, which is the admissibility and relevance of the 911 call. The key, and I'd like to point at actually a argument or a case that Justice Massing argued for the Commonwealth back in 1999, that a witness's state of mind is not admissible unless it is relevant. And that's Commonwealth v. McIntyre, 430 Mass 529. I'll include that in it's not cited in either my brief or my brother's brief, but I'll include that in a Rule 16 letter. The heart of this case is that both Ms. Solano's fear and also Helen's fear does not move the ball downfield for the crime charged. The crime charged is that it is objective standard and it is of Ms. Perdermo. It is not of Helen, it is not of Ms. Solano. So I think it is the relevance is minimal, where the undue prejudice is very high. It's going to confuse the issue.
Why isn't it just setting the scene? I mean, you've got the testimony of the victim, you've got the testimony from mother. You don't have the testimony of the daughter. Neither party called her. But isn't the daughter is a percipient witness here? Why can't why doesn't this substitute for the testimony of a percipient witness?
Because I think the undue it's I'll say this, and I want to make this very clear, is the objective testimony of any witness would be pertinent. He looked angry. He was yelling, all of these things. But once you go past that and go into the mind of someone and their fear is not relevant to the case, the case charged.
Counsel, wait a second. Maybe some of the questions that were asked, for example, of Ms. Solano, may have been objectionable, but I don't understand your argument to be that we should be vacating this conviction because of the questions asked of Ms. Solano. I understand this to be about the 911 call, right?
The first issue is, Your Honor, yes.
Okay, and the 911 call has in it a reference to the fact that my father is downstairs yelling and he made the following threats. Why are those not relevant? As Judge Massing points out, she's a precipient witness to the events.
Because intertwined with that is her fear. The emotion. I apologize. I thought that I had sent the audio of the call.
Oh yeah,
I
we
realized
heard it.
No, we've been able to hear it, I think, all of us. I'm not sure.
Okay. Thank you. And even in my brother's brief, I think we can all agree that it's highly emotional. I don't think you can take that. I don't think that a reasonable juror can take that emotion away from that.
But that's an argument that the call should be eliminated from evidence because of the emotion that's shown in the call. In other words, it's more prejudicial than probative. Not that it's not probative.
Oh, right. It is definitely the aspect of the relevance is minimal. I will agree that
relevance is minimal under circumstances where the defense case was that the mother was lying.
Well, there's a difference here, and I think this is key to my argument, is that as the case in chief, and there's a difference here, the case in chief, the relevance is minimal, and it is substantially outweighed by the undue prejudice of the emotion of the call. I do agree that it could, under certain circumstances, come in as rebuttal evidence, but it did not. And under those circumstances, it would have come in with a strong limiting instruction. This is essentially how I think this would play out from a fairness argument, is once the defense presented that argument, that the call then could be omitted with strong limiting objection just for the purpose to rebut the fabrication.
The order of evidence is within the discretion of the judge, right?
Yes.
And once the victim, I think it's Perdomo, once she's cross-examined, isn't it absolutely clear that the defense is going to be she's not telling the truth?
At that point in time, but the call was omitted.
Okay, but the order, whether the call came in first or the call came in second, once it's clear that as part of the Commonwealth's case, the defense is going to make the argument that the victim is lying, why can't the call come in?
It can't come in with a limiting instruction for that limited purpose for rebuttal.
Was one requested?
It was not.
So let's getting back to you're arguing that it's not that the victim, that the Helen's state of mind is not relevant to the issue of whether the crime of threats is committed against the mother, right? But with respect to the mother, we have to determine whether her fear, whether she had a reasonable fear, right, that the defendant was capable and intended to carry out his threat. Again, isn't the daughter's reaction to that probative to whether his threat was intended or not?
No, I think it prejudicially confuses the issue in the sense that any other it's difficult because we don't know if she's reacting to the threat to her or the threat to Ms. Perdomo. And Mr. LOANGO is only on trial. He's not on trial for his life. He's only on trial for this one count against this one person. I think it confuses the issues tremendously when you start bringing other crimes. It's akin to almost specific unanimity issue where, well, he's guilty of something. He's only charged with this one count against this one person.
Right, but isn't in terms of the mother's reasonable fear, isn't the fact that there are other people who are fearful too, isn't that relevant?
No, I don't think so, Your Honor. I think that, well, if it is relevant, then it's outweighed by the undue prejudice. I don't think it is. I don't think it makes that even if the ball goes downfield just a little bit, that someone else is afraid. What ties into it is the undue prejudice here of confusing the issues of what the crime is actually charged. For instance, and there's one case that I think that I've seen, at least that's cited in both briefs, that there's a witness testifying to their own fear. And that's Sholey, which is a 2000 case that's cited by my brother in his brief. There is, after the threat of the victim, there is reference to another victim's fear afterwards. However, my argument with that is it's a different threat. I don't know why it was admitted. It didn't seem to be the crux of the matter in that issue or that case. However, I don't think that other people's fear, once you go into the mind of someone, is relevant to the crime charge. I honestly
You mean, well, wait a second. Is Perdomo's fear relevant?
There's case law that says that she could testify to that.
It's an objective standard, but she can testify as to how she felt, correct?
Yes. That is correct, Justice Engler. Yes.
Okay, and then that leads us directly to Judge Massing's question, which is, why isn't the fear felt by two other contemporaneously percipient witnesses also relevant in a threats case?
Because that's not she's the victim. The victim's subjective fear can add color to the objective standard. But I think once you start going into other people in the room, it does not matter. Does
the fact that other people in the room were also placed in fear, is that some evidence of the reasonableness of the victim's fear, the alleged victim's fear?
I don't believe so, Your Honor. I don't. That once again, I think it once you go into the mind, they can obviously testify to what they saw, what they heard, all of those issues. That's fair game to lay down the track of what happened, the tone. He was red in the face. I mean, I'm just kind of, hypothetically here. He was red in the face. He was raising his fist.
So what's your best legal case for the proposition that the reaction of the percipient witness is not relevant to the reasonableness of the
it would be
victim's fear?
Sure. To that, it would be what I just cited, the McIntyre case, along with a combination of the 403 against the elements laid out in Maiden.
Okay, thank you.
Moving on to the third issue, if I may. I want to make this clear too, is that I think in a substantial miscarriage of justice analysis, when looking to the closing argument, that there was so much emphasis here. I mean, in the key to this too, and I want to make this very clear, and I think this is an important part, is on day 2, page 97, there's the reference of the judge who says the people's fear is not relevant. Other people's fear is not relevant in this case. For the reasons I just said, I 100% agree with that. And here's the internal conflict is, here's the judge who decides what's relevant. Now I agree that's not a ruling, but is internally conflicted where he's saying it's not relevant. After explaining that to the prosecutor, and the prosecutor acknowledges that, there's multiple references to other people's fear in the closing argument. I do not believe that's, and it is not objected to, so it is a substantial miscarriage of justice. But looking at, and in total, of all of the evidence that came in, and the lack of any kind of limiting instruction, any kind of curative instruction, that the conviction here is improper.
The first thing defense counsel led off with in their closing argument was, where are all the other witnesses? I mean, that was his principal theme. If this really happened, where are the people in the restaurant? Where are the people in the hair salon? Isn't it fair response to that to say there were 2 other witnesses, and here they were, and we know how one of them testified at trial, and the other one you can hear on the 911 call.
I think once again, it is fair as a rebuttal, yes. But I think that where it draws the line, especially in the closing arguments, is that there's too much emphasis with it. It led with the call. I mean, this was the fear of Miss Solano, and this is where it comes in outside of the 911 call. You know, just England, you made the point that the 911 call only deals with Helen's fear, but you know, in the closing arguments, these people were afraid. She relied heavily on the fear of other people, and I think that's impermissible. And there is no curative instruction, there is no limiting instruction. This went unadulterated. Sorry, I'm just.
Can I ask you a question about the rebuttal witness? You argue in your brief that the defendant's other ex-wife was called, and she put in for evidence of bad character. What evidence of bad character came in during her testimony?
I think it's not the strongest argument. I think quite honestly, it's of the 5 arguments, it's the weakest. But I think it's something I wanted the court to note. In once again, especially that to the standards in the arguments is substantial miscarriage of justice. The bad character evidence is just that. You know, I think the argument would be that you know, Helen didn't want to go with him. He only wanted to go with him when she was there, and then also just the fact that you have the ex-wife testifying in and of itself, you know, standing, you know, taking the stand, I think just goes down a rabbit hole that just kind of would be prejudicial.
So just her very presence and the fact that she said that the daughter was reluctant to go with the father is evidence of his bad character.
I think in total of the trial, yes, Your Honor. I will note this, just as my time is expiring, that one factor that was not in my brief that I just like to highlight in looking at the reasonableness, the reasonable alternatives of what the judge had when admitting the call, is Miss Solano, who was in the room, was just on the other side of the courtroom doors waiting out there. She did not testify. She was not asked anything about that, and I just would like to note that. Other than that,
All right.
I didn't note that there'd be a few cases that I might cite in a Rule 16 letter, but my time is up. So
Your time is up.
thank you.
Thank you very much, counsel. Attorney O'Sullivan.
Good morning, Your Honor, and may it please the court, Shane O'Sullivan for the Commonwealth. I would like to start with the court's permission on the issue of the probative value and the prejudicial effect of the 911 recording. The Commonwealth contends that the probative value of this evidence was abundantly clear. Predominantly, or I think the strongest argument in favor of the probative value of this evidence was the corroboration that it provided to the victim. As Your Honors have noted, the primary defense here by the defendant was that this event did not happen, so that the daughter, Helen, had phoned 911, that the jury was able to evaluate the nervousness or the emotion in her voice, that there was a contemporaneous report of the incident. The Commonwealth would suggest provided strong corroboration that this event did in fact happen. Similarly, Ms. Solano's testimony provided additional corroboration, not only that the event happened, but the strength of the defendant's demeanor and the force by which the threat was made. Additionally, the responding officer also testified that the parties appeared shaken up upon arrival.
Is the daughter's fear relevant to the elements of the crime?
Your Honor, I believe that it is, and in addition to providing the corroboration, I think it's also relevant because this is an objective standard. So it's first of all provides, you know, a direct witness's interpretation of the emotion in that moment, the case I believe is most on point is the Shawley case. And in that case, the threat was made to a prosecutor in a courtroom to quote unquote watch out. In that opinion, they discuss and they say the jury may consider the context in which the allegedly threatening statement was made. In Shawley, that meant testimony from other individuals in the courtroom who apparently felt the need to leave their offices. There was testimony from a court officer that he felt concerned enough by the defendant's behavior and carrying on that he left his post as the sole court officer over a session to follow this defendant and to see where he was going and what he was doing. So I would suggest another person's concern or apprehension about the threat is relevant to the objective standard. In this case, in the instant
Concern
case,
or apprehension. So what about the question of Ms. Solano and how did you feel at this moment? Answer, very badly because I'm already a woman of age and my blood pressure goes up and down. That shouldn't come in, right?
No, Your Honor, I would argue that it should come in because, again,
It should come in how Ms. Solano felt when she's not a victim.
well, and I think it's
there's
important.
case law on this that says unequivocally, for example, in the context of sex offenses, that the feeling of the parent is irrelevant and shouldn't come in. Isn't this exactly analogous?
I would say no, Your Honor. And although Ms. Solano is not, I think it's important to remember, although Ms. Solano is not a named victim, this threat was also directed to her. Yes, she wasn't a named victim, but this threat was directed to all three of them.
Right, but isn't this exactly what your brother is right about? The only allegation of the only victim is Perdomo. So how she felt generally, that's not relevant. How Solano felt.
And I don't know how is the jury supposed to interpret how this threat was made, the context in which this threat was made without the direct percipient witnesses being able to testify?
They can testify about the threat. They can testify about whether they thought it was a threat made to Ms. Perdomo, I think probably.
I would say that they certainly can't.
They can testify, I think, I mean, this is the question your brother's asking, whether they felt fear, but how did you feel? Well, my blood pressure was up. Stuff that's appealing to the sympathy of the jury, but is not part of the threat. That shouldn't have come in.
I don't view my blood pressure as up as appealing to the sympathy of the jury. I think that's her how she interpreted the defendant in that moment. And I think that's relevant to give context to the situation.
Actually, not what she said. Okay. All right. I understand your answer.
In regards to what prejudicial, and again, Ms. Solano's testimony is really not, I don't think, the main subject of the brief as well, and there was no objection to it. To get back to the 911 call, the prejudicial effect, even if it is viewed as inflammatory, the Commonwealth doesn't even view this particular 911 call as particularly. It is, yes, emotional. I don't know that it's inflammatory. The call was redacted in brief. The jurors were instructed not to base their decision on sympathy or emotion, both before and after testimony as a whole. No specific limiting instruction was requested at the time, nor do I believe the case law suggests that one is required.
I understand that argument, and we'll reach in a moment your reasons for why the prosecutor argued the phone call. But in the world of what I understand Attorney Murphy's argument to be on overkill, what about the use of the call by playing it at the outset of closing argument? I think his argument is there are places where whatever the propriety of the use of the call was, the bounds were overstepped to a degree that we should say was improper.
Well, and I would disagree, Your Honor. Again, it was powerful evidence for the Commonwealth to corroborate that this event happened, that a contemporaneous 911 call was made, and the prosecutor's argument essentially boiled down to, listen to the emotion in Helen's voice. That's not a person who's fabricating. I think that's a completely proper argument to make. For her to play it so that the jury can hear again that the emotion in her voice one time in the closing argument, I just don't believe is overstepping the bounds. It was evidence admitted in the case. It was not. If you look at the closing argument as a whole, I don't believe it was harped on. The prosecutor does describe Helen as being in panic, but looking at what she states before and after, it's clear that that's rebuttal to argument that the call was fabricated. Again, the prosecutor states that the responding officer found the individuals there in fear and upset. But again, it's clear from the closing that that was rebutting the argument that this was a fabricated incident. So given the defendant's defense,
I think the argument that's being made, and I just want to give you a fair opportunity to respond to it, is that all of that may be true. And given the high level of and the number of corroborating witnesses, that the playing of the tape is really an appeal to emotion, not an effort to put corroborative evidence forward.
And I would disagree, Your Honor. I don't think that this was this was the defendant's main defense. So the Commonwealth, I would suggest, has to have some leeway to make our strongest argument here. And this contemporaneous account of the incident was our strongest corroboration. We shouldn't be handcuffed in closing argument to not play an exhibit. I don't believe there's any words that the prosecutor used in closing argument that were improper appeals to sympathy.
Except saying that the daughter said, "I'm scared," when she didn't say that.
That was a misstatement, Your Honor. A
not insignificant one would think, although in context, perhaps not that bad.
I mean, she did sound scared. She asked for help. So, so it was a misstatement. It was a fleeting misstatement. It's not something that was harped on. And the daughter was asking for help in that moment. She did say, I think it was, I need help, or send help, or something to that effect. So, it's a 911 call. But I don't believe that playing it was an appeal to sympathy when looked at the context of what the prosecutor stated in the closing argument. I don't read it that way, and I think the Commonwealth has some ability to be able to use our best evidence to rebut the defendant's main defense. In addition, if I could cover the closing argument, just two other points I'd like to make is that there was no objection, which the Commonwealth would suggest indicates that the closing argument was not over the line, and that there was jury instruction, both not to decide the case on sympathy and also that the closing arguments were not evidence. I would just briefly say in Ms. Nunez's testimony, because Judge Massing had brought it up earlier in my brother's argument, the Commonwealth would argue that whatever character evidence was there, or bad character evidence, is not clear. Ms. Nunez's testimony in the Commonwealth's reading generally focuses on the visitation that the defendant had with his daughter, and the Commonwealth does not view that as being prejudicial evidence which was presented.
Can you remind me, what was the relevance of the visitation that she had to testify that he was saying there were no visits, and she said there, and the Nunez was saying there were lots of visits? Is that?
Essentially, that's it. Yes, the defendant testified that they had visited, I think it was 3 to 4 times within a couple of year period, and Ms. Nunez had testified that they had visited, once every 2 to 3 weeks, I think it was. And additionally, the defendant testified that part of the motive for making this up was this custody battle, whereas Ms. Nunez testified that in fact Ms. Perdomo had been I think in her opinion, it was, had tried to facilitate the custody visits in her experience during the time period that they were together. So it rebutted the defendant on those two counts. Unless there are any further questions from the panel, the Commonwealth would rest on its brief.
And seeing none, thank you both for your arguments. And while we are significantly past the new year, I wish to say to both of you that we wish you both a happy and a very healthy 2021.
Thank you, Your Honor.
Thank you. We can go.
All right, just give it a second while it actually streams. All right, we are live and recording.
Thank you very much. Welcome to the February 2nd sitting of the Appeals Court. My name is Mary Sullivan. On your panel today are Justice Massing and Justice Englander, as well as myself. The usual rules apply to this oral argument. We will hear from each side for 15 minutes. There will be no rebuttal. From time to time, it is possible that we may have technical issues, and rest assured that we will do our best to solve any of them. We hope that you will be as patient with us as we will be with you. For those of you who may be watching this, the screen may go black while we fix the technical issue, but we will return. And lastly, if you see any of us look away from the screen during the course of argument, we are not inattentive. It's simply that our notes may be to one side or another, and we mean you no disrespect. So that said, I'll call the next case, which is 19P1429, Commonwealth versus Matos. Attorney Rivera.
Good morning, Justice Englander, Justice Massing, Justice Sullivan, and may it please the court, Attorney Juan Rivera for Mr. Johan Matos. Your Honors, I am presenting to you today Mr. Matos's appeal on a conviction after bench trial. Our argument is that Mr. Matos should be acquitted of the charge of distribution or possession because the circumstantial evidence tends to equally sustain either of two inconsistent propositions, and neither of them, at least two propositions, and neither of them can be said to have been established by legitimate proof. It is a standard that has been set out by the Supreme Judicial Court back with Commonwealth versus Fancy 349 Mass 196, and that was citing the Commonwealth versus Carter case. In this matter, that is one of the arguments. The other argument is that the Sergeant Delaney, who was admitted as a Commonwealth expert, was improperly admitted as an expert. But the stronger of the two arguments, I would suggest, is the factual argument. When Officer Nunez basically saw what he described to be or believed to be a drug transaction in a Burger King parking lot, there were two vehicles. Officer Nunez observed one vehicle occupied by two individuals, a Mr. Cormier and a Mr. Patterson. These were not the defendants, and saw Mr. Cormier, who appeared to be the driver of that vehicle, making some phone calls, thought it to be suspicious, and continued to observe him, and then saw him get out from his vehicle and walk over to another vehicle. As this was occurring, the Officer Nunez, was in his vehicle. He describes his testimony as having been 5 car lengths away, and that he was observing him walk over to this other vehicle, and that he was actually driving slowly and moving while he was watching Mr. Cormier, who then ultimately approached a vehicle occupied by Mr. Matos and then Mr. Tejeda, who the officer Nunez described as the two Spanish males. He didn't know those individuals. He didn't know the individuals he had just finished observing.
But
He didn't know
Cormier, he observed Cormier to have money in his hand.
He says that at best, he describes seeing Cormier with money in his hand, but he does not, Officer Nunez did not see what was exchanged.
He saw money in his hand. He saw that hand go into the car window on Matos's side. And then when he confronted Cormier, Cormier had no money, but he had drugs in his mouth, right?
That's right.
And that's not enough for an inference that a drug exchange, an exchange of money for drugs had taken place?
That is enough for that inference, but there is also enough for another exculpatory inference. And that is, as I explained in my reply further to the Commonwealth's response. So the argument is that there is an inference to come to the conclusion that the judge came to here with this conviction, but that the judge did not fully consider all of the reasonable inferences here. And so on the bare facts that—
couldn't the judge, it's not that he didn't consider them, it's that he found them not credible, is that he determined they were wrong. Isn't that, I mean, there's a huge tension between the Lattimore standard of you look at the light and the most favorable to the Commonwealth, and then fancy, but which says if things equipoise, it's not beyond a reasonable doubt. But if a judge makes determinations of credibility and makes findings, it's not just because there's other evidence that doesn't make them an equipoise.
It doesn't make them equipoise if they're not considered. But I'm sorry, if I understand I understand your point, Your Honor. However, I think what is missing here is that the trial judge did not consider all the reasonable alternatives, all the reasonable inferences that were borne out by the evidence in the light most favorable to the
How do we know the trial judge didn't consider them and do what Judge Massing said, reject them as not being the inference that he believes is most persuasive?
Well, we don't know that he did consider that because there weren't any lengthy findings at the end of the trial. Not that the judge would have been required to give that, but that is that is my answer to that question. And with respect to the other reasonable alternatives, Mr. Cormier was already characterized by the Commonwealth through their direct questioning as a buyer, and he was labeled as the buyer through the entire—
that wasn't right, but there was no objection, right?
Well, there was an objection, but I don't think it was to that. I think that the objection was to what the buyer in quotation marks.
And where did they use the word buyer? Was that used by the officer or was that used by the expert, Deneen?
That was used by the prosecutor in her questioning to the officer.
Questioning of all the officers? I saw it in the question she asked to Deneen, who is the expert. Did she also do it in the questions to Nunez?
I believe so, yes.
But unobjected to, right?
There was no objection to that from the record. It does look like the prosecutor caught themselves and struck the word buyer, but then when there wasn't an objection, ran with it and just kept using that term. And so perhaps the lack of an objection was considered by the judge as something adoptive. I doubt it with a judge with this much experience. However, I think the expert, the so-called expert here, Sergeant Deneen, which is the second argument, added impermissible weight and impermissibly bolstered the Commonwealth's characterization of Mr. Matos as a distributor.
Why was that testimony inappropriate?
Well, the expert, any use of an expert, and typically the cases that have spoken on experts have to do with juries, and the experts have to be helpful to provide helpful information to a jury. In this case, there was nothing helpful that the expert could have provided to this to the trial judge, that the trial judge in
his experience and knowledge, this is what was observed was consistent with a street level drug transaction. Helpful? That's one opinion that he gave, right? In his experience and knowledge and training, what was observed by Nunez was consistent with a street level drug transaction. Why isn't that helpful to the judge?
Because it is a matter of, it is conclusory. It has to do with a fact that
no, it's an opinion. It's an opinion which an expert is allowed to give, right? And his opinion is based on his knowledge, training, and experience. The observations that Nunez detailed were consistent with a street level drug transaction. Not conclusory, because he identified all of the facts before he gave the opinion.
Well, there's a few issues with respect to the admissibility of the expert. I've already put forth our argument with respect to whether or not the expert was necessary. An expert is supposed to be helpful to a fact finder, and basically repeating an opinion that is, again, conclusory and supports the Commonwealth's characterization of the case on something where an expert is unnecessary, I would suggest is improper. And as I stated in the reply, that tips the scales. It tipped the scales for the judge to view the evidence the way that he did, rather than consider the reasonable alternatives that are in the case through the factual inferences. And I've presented some factual inferences that are similar to the Commonwealth versus Rodriguez, which was a case where an individual who, a woman had an interaction with a male. She dropped some drugs on the ground. That drugs were recovered. They stopped the defendant, and then that defendant dropped something that was later tested to be drugs, and that defendant was charged. But later, what they found, and this is Justice Gantz writing that opinion, that there were sufficient inferences, even with all of that circumstantial evidence. And so what I'm suggesting to this court is that the judge did not consider the fact that these two individuals in the car, Mr. Cormier and Mr. Patterson, both had drugs. Mr. Cormier had the crack in his mouth, and Mr. Patterson had heroin in his sock. There is no suggestion that Mr. Cormier could have gone over there as a prospective seller who, after being rebuffed when he showed his product to Mr. Matos and Mr. Tejeda, after they said no, because we have our drug of choice, which I believe was cannabis that was found on them, he could have left and tried to play it off, put his hand to his mouth, do some sort of motion in that sense. There was no suggestion that
What about the money? What about the money?
There's no money in the evidence. There was no money submitted into evidence before the judge. There's only...
No, there's evidence that he had money in his hand, and then there's evidence that they took money off of the passenger in your client's car. I mean, you're arguing that there's the evidence is equal that that Cormier was the seller, but he leaves with as a seller. His money is taken away and he comes back with drugs.
Well, that again, the officer Nunez, did not observe what, if anything, was exchanged in the vehicle. He saw Mr. Cormier carrying what he says was currency. There is an indeterminate amount. There is no physical evidence of any currency entered into evidence to support that. So it's only his testimony. And
only his testimony. This is exactly what Lanigan deals with. I mean, it's evidence. It's in evidence. It was appropriately in evidence. He observed the fact that there was money in his hand. Isn't that enough? That means there was money.
But it doesn't mean...
For purposes of an insufficiency of the evidence argument, which is what you're making. Can I just, because you're almost out of time, ask one question? A good chunk of your brief addressed the question of whether or not it was appropriate to have expert testimony like Officer Deneen gave about whether or not this was consistent with a street level drug transaction. And I went back and I read also the argument, which was quite detailed, which had been made to the judge below, about the application of Lanigan factors. And my question is, what methodology is it that you think would be sufficient for an expert like this to testify and give his opinions? What methodology would be enough?
Well, the expert was qualified, something in writing. There was nothing in writing. The expert had nothing prepared in writing. So there's nothing to compare it to. There is no methodology to compare it to. My time is up, but I'm trying to answer that last question.
Well, that's okay. We may have some questions for your brother on that subject. We'll see.
Thank you, Your Honor.
Thank you. Attorney McLean?
Yes. Good morning. May it please the court. Ian McLean on behalf of the Commonwealth. Your Honors, this court should affirm the defendant's conviction for distribution of a controlled substance for two reasons. First, the trial judge, Judge Coyne, did not abuse his discretion in qualifying Sergeant Deneen as an expert in street-level drug transactions. And second, there was sufficient evidence presented of distribution of crack cocaine here. Justice Engler, would you like to start where you left off?
Yeah, I kind of would. Let's start with your citation to the Canavan case, which I understand you to be citing for the proposition that if it's a non-scientific expert, that Lanigan doesn't apply. Is that your position?
Not necessarily, Your Honor. It's slightly more nuanced than that. Technically, Lanigan...
I hope it's a little more than nuanced, because if you went back and read Canavan like I did, you would find it says the opposite of what's been cited by the Commonwealth.
Yes, Your Honor. It expressly acknowledges that expert opinion based on observation is still subject to the Lanigan analysis. But if you go...
Thank you. So what makes this appropriate expert opinion? Is there some methodology or something that will establish the reliability of Judge Deneen, I'm sorry, of Officer Deneen's testimony to our satisfaction? What do you think is enough?
Well, first, I'll let him know next time I talk to him, he's been promoted to the judiciary.
Don't do that. Tell him that you can tell him that I misspoke.
Yes, Your Honor. I'd start off by pointing you to page 413 to 14 of the Canavan case. And there, in the SJC's words, they acknowledged, in many cases, personal observation alone will be a reliable methodology to justify an expert's conclusion. So there they expressly acknowledge that the methodology can be based purely on their observations. The problem in Canavan was it was a medical doctor that was offering a diagnosis of a medical condition on the basis of something that happened to the person. They didn't explain how they went from the event that occurred to the person, the chemical exposure, and how that led them to conclude that they had this diagnosed medical condition. So there was nothing linking the two.
So you agree there has to be some some methodology that results in a court being able to make a gatekeeper determination that the opinion they're about to hear is reliable?
Yes, Your Honor, because the Dalbert-Lanigan test does still apply, but I would point you to also to the Goodman case from the appeals court in 2002, acknowledging that the Lanigan test has to remain flexible because of the wide range of expertise and opinions that could be offered in cases. So I would then point out that, back to Canavan, noting that personal observation can, in and of itself, be a sufficient methodology. And then I would point you to a couple of cases where this.
Well, it has to be, it can't simply be personal observation in one instance. I mean, expertise has to be developed over time. It has to be
Yes, Your Honor.
personal observation from which one has sufficient set of data to render opinions as to what happens in another instance, right?
Yes, Your Honor, absolutely. So we're kind of blending the two questions together there between whether this would be a qualified expert and the field of expertise. So this field of expertise, characteristics of a street drug transaction, has been repeatedly recognized. I point you to the Nelson case, the Miranda case.
Yeah, Nelson didn't really say that either. Nelson isn't about determining whether you're looking at a street level drug transaction. Nelson is about whether you can identify a drug as marijuana.
Yes, Your Honor, that was the specific thing.
That's a different kind of observation, right? I didn't find Nelson helpful at all. In fact, I didn't find any case that was cited to me by you folks helpful on this subject, which is why I'm questioning you.
I understand, Your Honor. I'd point you to Miranda that expressly recognized that it's settled law with a string side of cases.
Okay, hold on. Maybe I need to look at Miranda. 441 Mass 783?
Yes, specifically at 793, Your Honor.
Okay.
So in Miranda, that case was about methods of street-level heroin distribution, and they expressly acknowledged that characteristics of street-level drug transactions are a field that's beyond the knowledge of the average fact finder, and therefore it's an appropriate and admissible field of expert opinion.
That makes it, that gets it through the first stage of the gate, right? That
Yes,
this
Your
is
Honor.
something that the average person isn't going to know about. I think
Yes,
it's
Your Honor.
probably going to depend on where the average person lives, but for general purpose, the average person is not going to have seen let's just accept that proposition. But we still have to get past where is the dividing line between anecdote and methodology? And at what point what is this? And these are related questions, but they're not the same question. And I think you've been helpful in trying to get us to separate out our issues. What is the difference between, what is the scope of the area of expertise? I mean, and I'll give you a for example that has always, we see argued frequently here. The drugs were in baggies, that means that they were intended for distribution. And the counter argument is, yes, but that's also how you buy them. How is that evidence of distribution? What, for purposes of methodology, how do we define what the method is and what the scope of the area of expertise is?
Yes, Your Honor, here I think that, so the Barbosa case has the 5 prongs to hit to admit any expert testimony. The first being assisting the trier of fact. The second being, was this witness actually qualified? The third through fifth really being the Dalbert-Lanigan, the components of the Dalbert-Lanigan test. So here in this field of expertise, the witness being qualified and then the 3 through 5, the Dalbert-Lanigan methodology and reliability things kind of bleed together in that analysis, because this is a field that's based on personal observation when combined with training and experience. So here what happened was the Commonwealth provided a motion in limb in writing in advance of the trial beginning and proffered the field that they were talking about, which was street sale drug transactions, including packaging and prices. As Your Honor just pointed out, frequently that's discussion about cutting the corners of a sandwich bag and then putting drugs in the corners and tying them into twisties. So that is something that's beyond the average knowledge of a lay juror. So that is an appropriate area. Then we need to make sure we have a witness who can testify based on their knowledge, training, experience, observation, that is how drugs are sold. That doesn't necessarily mean this testimony gets us to establishing who was the buyer and who was the seller, just to the fact that these drugs that were discovered were something that would be used, packaged in a way that would be used in distribution, in a street level distribution situation, a sale.
Yeah, I think that what you need is reliability, because that's what Lanigan talks about, an appropriately reliable methodology. And there are two pieces to it which are escaping me at the moment, but it basically comes down to that you have a methodology that's been shown to be reliable. And it seems to me that I know that corners get cut, and I know that the cases actually say, as you point out, and Miranda helps me on this, thank you. If it's something that's been presented as expert opinion in the past, as an area in which expert opinion is appropriate, that it's highly likely that it still can be appropriate expert opinion in the future, right? But I would think that when these folks are testifying, what they need to do is connect up their experience to what they're testifying to. I've seen a lot of drug transactions is too conclusory to get you there. It seems to me. I think he needs to say, I've witnessed this, and then I've been able to determine that it was a drug transaction because I arrested the person and they had drugs, or I arrested the person and they told me that they were engaged in a drug transaction. Something that gives us a basis for a methodology.
Your Honor, we have that in this case. I point you to the transcript at page 62 and 63, where Sergeant Deneen testified specifically to having performed countless undercover buys himself and participated in over 1,000 drug arrests. So in addition to him being a member of the drug control unit for 10 of his 20 years while with BPD, he also had specialized training from the FBI and the DEA on undercover purchasing of drugs undercover. He'd been an FBI task force member for undercover purchases. He taught classes for the FBI and for the BPD drug control unit. And then he indicated he had performed countless undercover buys himself. That's direct firsthand experience, and participated in over 1,000 drug arrests.
All right.
On the basis of that, he's then testifying about what it is that he's seen in these undercover purchases, how
What
the
are
drugs
the, what are the factors or circumstances of a common street level drug transaction under circumstances where I've done thousands of them myself?
Exactly, Your Honor. So packaging, pricing, and the sort of observations that you would see how the transactions actually tend to occur. So that's sort of where, and so back to your question, Justice Sullivan, that's sort of where blending the two components of the test, this particular witness's qualifications are part of establishing sort of the reliability of the methodology. So that second prong in the 5-part Barbosa test sort of bleeds into the 3rd through 5th, which would be the technical Dalbert-Lanigan components. So in a field where you were talking about scientific, like a GPS or something, or DNA is the example people always use, those 5 components of the Barbosa test will be much more clearly delineated or broken out.
What do you say to the, I'm sorry.
Go ahead, Your Honor.
Maybe you're still answering Judge Sullivan's question. I apologize.
If I could, I was just going to say you're drawing the distinction between the so-called hard sciences and the so-called soft sciences, but oddly enough, I put the drug deal testimony in some measure in the same category as psychiatric testimony, which is it is less susceptible to scientific proof in the manner that we would see in matters of chemistry or biology. I take it that your argument is that wherever the dividing line may be between anecdote and methodology, it isn't here because this particular person has 1,000 buys and 10 years of experience.
Exactly, Your Honor. That's exactly right. And the flexibility or fluidity of the Dalbert-Lanigan process is acknowledged by this court in the Goodman case back in 2002. And it's for exactly situations like this that don't fit squarely into the
So what do you say to the argument that was being made below, and it's adverted to in the briefs here, to the effect that you need some science, you need some data, you need something that says we've studied this many buys and this is what we determined with respect to how many times this happened, how many times that happened. We don't have any of that, right? We don't have a publication.
No, Your Honor, no publication, but what we do have is this particular expert indicating he had specialized training from the FBI and the DEA and had been a task force member for a number of years for the FBI, and now he is actually an instructor in the subject matter, having taught a class for the FBI on undercover drug transactions operating as an undercover agent or officer.
Would that
And-
be sufficient if we went into a different field? Let's say we go into the field of psychological evaluation, whether someone is a sex offender, for example, and someone says, well, I've interviewed 1,000 sex offenders, and let me tell you, this person has this problem.
Well, I think,
That
Your
could
Honor,
be sufficient?
I'm not sure. I don't think so, because I believe you're talking about diagnosing a medical condition, and there's a regulatory board body that exists to allow somebody to have a medical license to be able to diagnose a
But
person
now
with a condition.
Now you're just, I mean, you could have a board that says police officers, before they testify about drug deals, need to have a board that sets forth a series of factors. And they don't, right?
No, they don't have a board, Your Honor, but they have a promotion system and an assignment system. And then this particular officer was recognized by his peer group as a person who was qualified to train other people in how to recognize these things.
My point, counsel, is this. If you won't accept what I hypothesized as an expert in psychology testifying about a sex offender based solely on their experience, why is it we should accept your expert in your field? I'm struggling to get the distinction between the two for purposes of a Daubert-Lanigan analysis.
Well, Your Honor, I understand your frustration, and I'm going to point you right back to.
It's not frustration. It's simply questions.
Okay, your curiosity, Your Honor, and I'm going to point
Thank you.
I'm going to point you right back to Miranda, Nelson, and Frangipane that says a Lanigan hearing is not even necessary when this field of expertise has been accepted as being reliable in the past. And this field of expertise, recognition of and characteristics of street level drug transactions are well recognized in the courts of the Commonwealth. This particular expert was well qualified to provide that information on the basis of his 10 plus years in DCU, his 1,000 drug arrests he had participated in, and countless buys that he had conducted himself. And then I would also.
Can I ask a different question?
Of course, Your Honor.
I want to ask about the Judge Coyne's comment when he's qualifying Sergeant Deneen, that the record should reflect that the sergeant appeared before me countless times and he's been qualified. What is the relevance of that? Is that appropriate?
The only part of that component is relevant, Your Honor. That a person has qualified as an expert in the past in other courts is relevant to the consideration of whether they will be deemed an expert in this course. That case, it was irrelevant that expert had qualified in front of Judge Coyne in the past. But even if you were to set that comment aside and just look at all of the rest of the things that he testified to, he was well qualified, Your Honor. BPD for 20 years, 10 years with DCU, specialized training that he underwent, that he is now an instructor for both the FBI and BPD, and all of his experience conducting these undercover buys and arrests.
Can the judge take judicial notice that Deneen has been qualified before in other cases in the VMC before the same judge?
Yes. So he can take judicial notice that this expert has been qualified as an expert before in other cases. Yes. What he can't do is factor in things that he testified to in his voir dire in other cases into this case. But there's plenty here to support the conclusion that this officer was qualified to testify as an expert. And if there are no further questions?
I'm looking and seeing none. Thank you both for your arguments.
Thank you, counsel. Very interesting.
Thank you very
And
much.
may we wish you a happy and very healthy balance of 2021.
All right, we are live and recording.
Good morning, everyone, and welcome to the February 2nd sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan, and your panel today will be me, Justice Gregory Massing, and Justice John C. Englander. I will start by noting that I recognize that we have a small technical glitch this morning, which is that my video is out of sync with my voice. We sincerely hope that that is the only technical glitch we have today. But if we do have any, please be patient with us, as we will be with you. For those watching on YouTube, if we do encounter technical difficulties, we may go black while we fix them, but we will be back. The usual rules of oral argument apply today. Each side will have 15 minutes in which to argue. There will be no rebuttal. You can assume that we are well versed with your case and you may proceed directly to the heart of your argument. And lastly, if you happen to see us look away from the screen, it's not that we're inattentive. We have iPads that have our notes and the cases. We may be looking at a law book. You do have our full attention. We are just looking at our other materials as we would in a usual day at oral argument were we in person. And so with that, I'll call the case 20P0691, Commonwealth versus Barrieault. Attorney Vizone, you may begin.
Thank you, Your Honor. And if it pleases the court, my name is Joseph Vizone and I represent Nicholas Barrieault. I have three issues today for the court's consideration. The first issue is whether or not the evidence was sufficient to convict Mr. Barrieault of either form of assault. And I will start, Your Honor, with a threatened form of assault, an imminent battery. And the major question for me, at least in my mind, is would a reasonable police officer believe that he was about to face an imminent battery, that he was being threatened? And I would suggest to the court that no reasonable police officer, given the facts of this case, would have been able to entertain such a thought. First of all, the police officer was standing behind an open cruiser door, and he had a loaded rifle pointed directly at Mr. Barrieault. In addition to that, there was another police officer who showed up, Officer Minicello, and he also removed his rifle from the cruiser. And the other police officer, whose name escapes me at the moment, but he had a handgun. And so in that situation, the defendant was holding a folding pocket knife. There was no way that he could ever.
The defendant was holding a knife,
yes,
and a bottle, dancing in the street, and was told multiple times by the officers to drop the knife, which he refused to do. And instead he advanced. Why is it that a reasonable person, and I'm not sure that the standard is a reasonable police officer, why is it that a reasonable person would not perceive themselves to be under threat? The fact that they were armed and used their arms would suggest that they did believe that they were under threat.
Well, they had their arms in a ready position. They did not use them. No police officer ever.
No, but why in the world would they pull the gun out and be in a ready position if they didn't think that they were under threat?
It could have been, well, again, Judge, the record is pretty much silent on that. We'd have to speculate. Perhaps it's just police. Quite frankly, I think it was police overreacting. You would have a young man with a pocket knife. If the young man had a firearm, Your Honor, then I wouldn't be making this argument to the court because it would be meritless. But there is no way.
Isn't that exactly what's for the jury, though? If we look at the evidence in the light most favorable to the Commonwealth, wasn't it for the jury to decide whether they could see exactly what was in the officer's hand, whether they were reasonably in fear when he refused their commands and continued to advance?
Well, it's a jury's question. Yes, it's always a jury's question. I mean, they're the ones that decide the facts taken in the light most favorable to sustaining the verdict. But again, there is a question of would a reasonable person believe that he was being threatened? And a reasonable person, whether that person is a police officer or not, cannot feel that he's about to face an imminent there is a threat of an imminent battery, because the imminent battery under these facts is I would suggest to the court, is a physical impossibility. There is, if he had a firearm, if Mr. Barrieault had a firearm.
What if he was an expert in throwing knives?
Well, I addressed that in my brief, and I believe that based on the time, the evening in March, and being up in Fitchburg, where it's pretty cold. I know I've been up there a number of times when I was an ADA. And the officer would have had the windows of the cruiser up. There would have been no reason to have the windows of the cruiser down. And so I don't think that he would have tried to throw, especially a pocket knife, maybe a Bowie knife you could throw.
Is the picture of the knife in the record? I can't find it.
It is not, Judge. I believe it was just described as a folding pocket knife, which, was a folding pocket knife. That's the way it was described at trial.
So there's nothing in the record that indicates what its length is or anything else, right? So
Correct, Judge.
you say pocket knife, and I think of something that my kids.
Boy Scout knife.
Yeah, but we don't know that. It's
Well,
not
it's
described in the record.
correct.
We don't have the photograph.
We do not. I do not believe that a photograph was entered into evidence, Your Honor.
And
yes.
it was big enough, apparently, that even at 10:30 at night, multiple people could see it from a distance, right? In his hand. The first witness saw it in his hand. Every officer saw it in his hand.
Well, no, I agree. No, the officers knew he had a knife in his hand. There's no, I don't dispute that. They knew it was a knife.
Well, but
Without
then the
question.
suggestion that it's tiny isn't necessarily consistent with what I can divine from the record, because everybody at 10:30 at night knew this guy was waving a knife.
Well, there was also testimony, Your Honor, from a couple of police officers that he was not waving the knife, that he had
I'm
the
sorry,
knife
I apologize, wrong word. I
over his head, and that he was not yelling. He was not yelling any threatening words to the police officers. He was not using any vulgarities, obscenities. He was just walking with the knife over his head, not in a threatening position. And I agree, he should have dropped to the ground as soon as they gave the first command. He did not do that, but eventually he did. But again, would a person in the police officer's position holding a rifle behind a car door believe that he was in threat of an imminent battery?
Is that the right question? It's very well constructed by you, counsel, but I think Judge Sullivan's question is a pretty good one. Let's assume he didn't have a rifle and there's a man approaching him with a knife who won't drop it. Isn't that enough to establish that he's threatening? So then he pulls out a gun because, you bring a gun to a knife fight. But isn't Judge Sullivan right that the question isn't necessarily, was it a threat at the time he pulled his gun out? The question is he a threat when he's advancing on him with a knife?
Well, again, with all due respect, Your Honor, you're changing the facts. This police officer, as soon as he got out of the car, I'm going to talk about Officer Robichaud, because he was the person that Mr. Barrieault his focus was on. He immediately pulled his rifle out of the cruiser, okay? And he had his rifle, and he chambered around. And all he had to do was squeeze his index finger, and that would have been the end of Mr. Barrieault if the officer thought.
What if he'd put the rifle down?
But he didn't. The question is,
because
the mind of the police officer, the reasonable,
maybe.
What is in the police officer's mind? Would a reasonable person holding a bolt action rifle, or whatever kind of rifle it was, I don't know if it was a bolt action, but holding a rifle with a bullet in it, and a man behind an open car door, and somebody is close enough to you that you couldn't miss if he tried, he couldn't miss. Okay, how would that person be in fear of an imminent battery? I don't see it. I mean, obviously
the problem isn't
Yes.
the other problem with your argument, counsel, that they were required. They knew that they were going to have to arrest him, which meant that they weren't going to stay in this defensive posture. That what they were trying to do was interrupt his behavior long enough in order to be able to safely and securely subdue him. And that knowing that they were going to have to move in and arrest, that this behavior was objectively threatening.
Well, again, I don't think they would have moved in until they felt that they were in a safe position. If they really felt that they were about to be stabbed or slashed, they would have discharged their firearms. They could have shot him in the foot.
Is that really a legal standard that we want to apply to our police officers, that they couldn't possibly be afraid and therefore they can shoot? Isn't everything we've learned in the last year or so that officers are afraid? And that's when the guns get pulled?
Well, yeah, yes, again, but I think we're interjecting facts into a situation. This situation happened in 2018. These police officers could not have known what happened in the last year in terms of police officers confronting.
It's not new or different.
It's
I'm
not
sorry, Your Honor?
new.
It's not new and it's not different.
What I'm saying is in 2018,
It's not new and it's not different in 2018. How can we possibly say that police officers do not get the benefit of a legal standard that permits them not to be threatened by people with weapons? It's not a very articulately phrased question, I apologize, but if a police officer is being advanced upon by someone with a knife, is it not a jury question whether or not they're afraid?
well, again, Judge, the facts in this case are that eventually Mr. BARRIEAULT dropped the knife after he was requested to do so, albeit a number of times, several times, and he got into a sitting position, he claims because of his physical infirmities, and then he finally got down into the prone position, at which point the police officers were able to take him into custody. But again, to charge him with either form of assault in a situation, especially the second kind, an attempted battery, on page, I think it was page 13 and 14 of my brief where I discussed some factors. And, what's the probability that he could have carried out, that he could have been successful in actually committing a battery? And my point is, again, it was a physical impossibility, given that there was a car door between the police officer and Mr. BARRIEAULT. And Mr. BARRIEAULT was certainly well aware that he had a rifle trained on him. So if I may go on to my second issue, Your Honor, if there's no more questions for the court on the first issue. Second issue, Judge, and this goes only to the disturbing the peace or disorderly person. The witness testified that she could not identify the defendant. There was no identification of him at the scene, which spills over into my third argument. And also, Your Honor, her physical description of him was a white male, kind of tallish, wearing a long tan coat. Well, we know that Mr. BARRIEAULT is a white individual. I don't know how tall he was.
Counsel, maybe I'm missing something, but
Yes, Judge.
why can't the evidence of the officers, all of whom identified your client, be sufficient for a disorderly person?
But that was after the fact.
No,
What-
they observed him in the middle of the road with a knife. That's not enough?
Well, I think the testimony of disturbing the public order was was the conduct that occurred prior to the police officer showing up, because there was nobody out there. He was not disturbing anyone's peace. There was nobody out there with the exception of the young woman who was in the back seat of the car, who called the police dispatcher and said, there's a gentleman out here and he's, dancing around.
No, there was testimony that there was a fair amount of traffic still at 10:30 at night. One of the officers said that.
Right.
And the evidence of the officers is that he's in the middle of the road with a knife. That's not enough?
To me, that goes more to the assault and disturbing the peace. But
So your view is that the charge really had to do with her testimony alone?
yes, Judge. Finally, my third point, Judge, is about the identification. Is basically that it was the prosecutor who identified the defendant in court. This witness, civilian witness, young woman, could not, as I said before, identify the defendant. And it was the prosecutor who said, oh, the defendant was standing here. And so for the reasons that I've stated in the cases in my brief, I don't believe that was proper for the prosecutor to do that. It bolstered the identity issue. And of course, there's no question that somebody disturbed the peace. The issue was who did it, who disturbed the peace, and that goes to identity. So
let's assume that the question was improper. Where's the prejudice? I mean, did the officers arrived within 2 minutes of the call? She testified that she watched him and stayed on the line, I think, with the 911 operator. and that she took her eyes off him after the police arrived. How do we get another person in there with the same bottle and the same knife?
Well, I think the problem is that the description that she gave a totally different description of the person she saw, was being tall, a tall white fellow with a long tan coat. And the police officer said, no, he had a black and yellow waist level jacket on. A waist level black and yellow jacket cannot be confused with a long tan coat.
So there's a conflict in the evidence about what the coat was, but what's the evidence that another person appeared?
It would have been the way that person was dressed. She saw it. The argument here is that she saw a totally different individual.
Okay. All right. Are there any other questions? All right. I think your time is up. Thank you very much.
Yes, Your Honor. Thank you.
Attorney Bowden.
Good morning, Your Honors. Nathaniel Bodwin for the Commonwealth. A couple points I want to make first. There, in addition to the evidence that Ms. Stevenson called 911, one of the officers, I believe, Officer H, because I can't pronounce his last name, he testified that there were multiple 911 calls to the Fitchburg Police Department that night reporting a knife-wielding man blocking traffic in that area. So the officers were expecting to be confronted with, again, a man with a weapon. In terms of the issue about the defendant's coat and what he was wearing, yes, there was, Ms. Stevenson testified that it was a tan coat. Other officers, I believe, in their police reports referred to it as a yellow coat. Officer Robichaud did indicate, however, that it was a long coat. And he talked about how Officer H was trying to arrest the defendant, and there was some concern because of the long coat he was wearing as to whether he had additional weapons on him. So it was unclear for the officers at the time whether he just had that one weapon.
Was this a pocket knife?
It is a pocket knife, Your Honor.
How long was the blade?
But first I will say that a picture of the knife was introduced as evidence as Exhibit 1 at trial. And yes, it is. And yes, it is what I would describe as a typical pocket knife. There's no testimony. I'm looking at the picture right now. There was no testimony about the
prosecution of this guy who went to jail for 15 months was because he had a pocket knife that he had in his hand in the middle of the road.
Your Honor, he was convicted and sentenced because he was holding a knife in the middle of traffic, blocking traffic, dancing around, putting both pedestrians and drivers at risk while he was doing that. And so there's no question to me as to whether the size of the knife.
No. He didn't go to jail for 15 months for doing that. He went to jail for 15 months because he approached the police officers with that knife.
You're correct.
And threatened them. He didn't get his sentence for the disorderly person. In fact, that was placed on file, and there's some question in my mind as to whether it's appropriately appealed. But we'll figure that out.
Yeah, no, so yeah, that is very true, Your Honor. I misspoke. The disorderly conduct was guilty filed, but it was both the resisting arrest and the assault with a dangerous weapon, concurrent 15-month sentences there. And in terms of both theories of battery, both theories of assault with a dangerous weapon, I do think the evidence was sufficient under both forms. I believe it came out in with the attorney of his own argument. It appears the defendant is trying to change the reasonable person standard to a reasonable police officer who is armed. In addition, the defendant argues that somehow Officer Robichaud's testimony that he was placed in fear was somehow disingenuous. Again, appellate courts don't weigh the credibility of witnesses, so that's not really at issue here.
Can I ask you, Attorney Bodwin, let me ask you, on the reasonable person standard, is it a reasonable person who's unarmed or a reasonable person who's armed?
The way I read the case is it's just a reasonable person, and they don't distinguish whether a person is armed or unarmed. And I think a reasonable person, if they were to have someone walking towards them with a knife raised in their hand, a reasonable person would find that to be threatening, including when you have officers in the area or anyone in the area,
Well,
really.
the usual formulation is a reasonable person under the circumstances as described in the facts of the case, right?
Certainly, and even if we were to say the reasonable person in the facts of this case, like I stated earlier, the officers were unaware whether this individual had other weapons on him at the time because of the long coat he was wearing. They knew he had a knife. They didn't know what other weapons he had on him. And again, he was refusing to comply with those demands to drop.
But they did have rifles pointed at him, and isn't your brother correct that that fact is part of the totality of the circumstances bearing on the objective reasonableness of their fear?
I think that the officer holding a rifle could still be in fear of an assault because the defendant could have thrown the knife at him or the bottle, thrown the knife at him. He was still in danger of a battery despite holding a weapon of his own. And in terms of the other two issues, I'll just close with the final issue about whether the prosecutor identified the defendant in court. I believe the prosecutor should not have referred to him as the defendant. I believe he should have said the man or the man you saw in the street. However, I think it was made clear to the jury that those three officers specifically identified the defendant in court. Ms. Stevenson did not. It was also made clear to the jury through the prosecutor's questioning that Ms. Stevenson did not know the defendant beforehand, and that she was viewing him from 2 car lengths away. And again, her description was a tall white man with a coat, and that was sufficient in terms of identity. And just to make clear, one last thing is that Stevenson testified that she stayed on the phone with the police. I think in the brief it says that she hung up the phone and continued to watch the defendant after the call. The testimony was that she continued to have a conversation with the dispatcher till the police arrived, and of course, the police officers identified the defendant as the man.
Legal question for you. This is a general verdict on the assault claim, right? The jury were given 2 different theories. They don't have to be unanimous on the theory, but do we have to find there's sufficient evidence for both theories?
I don't believe you do have to find there is sufficient evidence for both theories. I do believe there was, as I argued in the brief, but there was no special verdict.
Well, the usual rule would be if there was insufficient evidence on one of the theories that was presented to the jury, we'd have to overturn the verdict. That'd be the usual rule. And I saw that case you cited. Unless you want to disabuse me of that.
I would just say, Your Honor, that I feel confident in the evidence presented here was sufficient under both theories. So I don't think we have to hope. The Commonwealth does not hope we have an issue with that here.
Well, you know, it's an interesting, sorry.
Go ahead.
I was going to say it's an interesting problem, and one that you as counsel for the Commonwealth at the appellate level might need to think about a little bit. I mean, the usual rule is if 2 different theories are presented to a jury, and one of those theories, the evidence is insufficient, and you don't know, and the jury doesn't come in on both of them, okay, gives you a general verdict. The general verdict can't stand. That's the usual rule, at least as I've understood it for 3 or 4 decades. So if it's different when you're alleging assault, and there are 2 different ways that you can get to assault, that may be the case. That's what I understood the brief to say, but I didn't go and check the case. But I think that's what Judge Massing is getting at.
And I would just say, I think my best recollection of that case says that as long as the Commonwealth proves one theory, I'll have to take a closer look at that. And if I find anything that is inconsistent with that, I can provide a letter to the court.
Well, we'll take a look too.
And on the question of the guilty filed, is a guilty filed properly before us on appeal?
You know, I did not research that issue for this, but I do believe I recall that being an issue in some cases, whether a guilty filed case can be properly before the court. I can't give you a very intelligent answer on that without looking at the case law. I do believe I'm familiar with case
The
law.
answer is
That's
it can under some circumstances, but in general, no.
If
Anyway.
either of you would like to file a 16L letter simply citing cases and not making argument on that issue within 5 days of today's Tuesday, by next Monday close of business, you're welcome to.
Your Honor. And if there are no further questions, the Commonwealth can rest on its brief.
Seeing none, thank you both. And as we proceed through February of 2021, may we wish you and yours both a happy and a safe and healthy year ahead. Court, my name is Mary Thomas Sullivan. The panel today will consist of me, Justice Gregory Massing, and Justice John Englander. The usual rules of oral argument will apply. Each side gets 15 minutes. There will be no rebuttal, and you may assume that we are familiar with your case and the records. As those of you watching on YouTube may have already realized, there appears to be a time delay between my voice and the visual. I don't think that we'll be able to get that fixed today. We hope that there will be no other technical problems. If there are, we hope that you will be patient with us as we will be patient with you. And we may need to go offline if necessary in order to fix the problem. But if we do, we will come back and complete the argument. One last general note, if we happen to look away from the screen, it is not because we are inattentive. We have our other materials, our case materials to the side. And so if you see us looking in a different direction, we are listening to your arguments and we mean no disrespect. Now, with that, I will call the next case, which is 20P0021, Department of Children and Families versus Mother and others. I will remind everyone that this is an impounded case and that we are not to use proper names. And with that, you may begin.
So, Your Honor, my name is Jean Kaiser and I represent the appellant mother who has brought this appeal. As you probably are aware of from the record, this has been a long, hard case in many respects. It's complicated procedurally and factually, and it's been fraught with many delays. Nonetheless, the mother has determined to pursue her appeal, and I'm going to stress 2 points on her behalf. First, in any case involving termination of parental rights, the trial court is required to make specific, detailed, and accurate findings. And the purpose of those findings is to show that there is clear and convincing evidence of unfitness to assure that the parent is not being deprived of their constitutional right to care for their children as they see fit. In this case, as pointed out in my brief, the findings of fact and conclusion of law give some reason to be concerned that the trial court was inattentive. The trial judge included in the procedural history very inaccurate facts, quite inaccurate facts. The father died in the middle of the proceedings, and the trial court notes that he stipulated to his own unfitness.
So clearly, factual findings 1 through 9 are a mess. They have nothing to do with this case. And the judge, throughout the findings, she finds that the father died. I mean, there's no, it's just that's clearly an oversight there. The worst oversight there is saying that your client wasn't present when the only time. I mean, she did, as the DCF points out, she was not present for a few trial days, but those were all because of illness. So I think, drawing an adverse inference from her lack of presence would be a problem here. Although you don't argue that the judge made an error in drawing an adverse inference.
Right. I think it's pretty clear that the factual findings are inaccurate, and the judge doesn't really draw an inference in that way. I think, though, that that the sheer magnitude of the inaccuracies in the procedural facts should at least alert the court that there may be other inaccuracies. And,
Well, two things, counsel, in response to that, if I could. One, your sisters, I think, say that mother actually was not at trial, including the last day of trial. And so what is the actual fact? How many did she miss? And what do we know about that?
Your Honor, off the top of my head, I don't remember exactly how many days of trial. This trial took place over the course of years, and as you're aware from the facts that she has a serious illness that sometimes caused her not to be present. And again, I'm not arguing that. I'm just saying that what I'm
trying to understand. And so that was my first question. And let me just, to be clear, what I'm trying to understand is what was the nature of the errors that you're fixed on by this judge? One that seems to me to be significant is your sisters say mom missed several days of trial and it was appropriate to draw an adverse inference. And you say that was just wrong, that in fact, mom was at the trial, perhaps with some exceptions where she was ill. The second question I have for you, which maybe is more important, even if we accept that there were serious mistakes made, for example, whether she was at trial or not, as to the fundamental behaviors that are in the evidence, I did not see you calling out other facts and saying this was clearly erroneous. And if there are other findings by the judge that are mistaken, that go to the core behavioral issues, you should call that out to us.
Okay, so Your Honor, candidly, in the numerous facts, I don't think there are any facts that are flagrantly wrong. I just think that when the court is evaluating whether there was clear and convincing evidence of the mother's unfitness, it should take into account that perhaps there was a certain inattentiveness from the trial court. Because as the court is I'm sure, well aware, in order to find unfitness of a parent, the court must find not just that the mother wasn't a good parent or as good a parent as the proposed adoptive parents, but that her lack of fitness put the children much at hazard. And here the court did hear some positive evidence about the mother. She showed some strength in coping with her health issues, her mental health issues, the addiction of her partner. She had some good family support. And in fact, the trial court did not terminate her rights to her older daughter. So I think that those things taken into account are the things that the court should look at in determining whether the standard has been satisfied.
What was the deal with the older daughter? What happened with the older daughter? Because her name is on the petition.
Right, and that is another aspect of the facts that is just the findings that is just not really clear. I think in reading the facts, you really don't, she does not terminate the mother's rights with regard to the older daughter. And at one point she says the older daughter is in a pre-adoptive home. But there's very little attention given to the older daughter in the facts. So
what really happened though? Was she dismissed from the case?
Yes, and at this moment in time, well, I'm not going to talk about things that are not outside the record.
But so just in terms of this petition, that she was really part of it, she was dismissed by the DCF?
So, Your Honor, I was looking at this again this morning, and I think, to be truthful, I have conflated to some degree my knowledge of the case moving forward with my knowledge of the record. And when I was looking at the record again, I see that it's very inconclusive with regard to the older daughter.
But so we're not clear with that. Maybe the accounts for on the other side can help with that. But there's clearly a difference between the caring for the older daughter and the two twins who have severe health compromises and have just they're much more difficult to care for than the older daughter.
Yeah, Your Honor, it is a very difficult case when the children have issues like that, and really, you know, they've been in the custody of the department for a very lengthy period of time. It does create a difficult case. But the mother's position is that she is fit to care for these children, and she wants to pursue her appeal before this court and challenges the judge's decision below.
So you say that, so you don't really take issue with any of the judge's findings of facts with respect to this case. You say the court states that there are 4158s have been filed, but I don't see any citation to the record there. Where does the judge say that? I couldn't find it.
I don't have the findings right in front of me, but I believe he does. And again, you know,
Attorney Kaiser, I hate to do it this way, but under our rules, when you make a statement like that, you're supposed to give a citation to the record. And it says on your next page that you actually read the rules, including references to the record. You need to give us a citation like that. You can't just put a fact like that without a cite.
Okay, my apologies, because that is not how I characteristically do things. I have to look at my brief again
on page 17.
Okay, I will do that and correct that. But again, Your Honors, is a very tough case. It's been a long haul for the mother. The mother has decided to pursue her appeal. And again, I would just ask the court to be sure that the standards have been satisfied. And if you don't have any more questions, I will rest on my brief.
Seeing none, thank you very much. If you'll wait just a moment, we'll get the timer up and you will be able to continue with your arguments. Who will be arguing first? Attorney Gershon, you're on mute. You're still on mute.
There you go.
Okay, great.
So you'll be going first. All right, let's just wait to get the timer. There we go. You may proceed.
Thank you, Justice Sullivan. And good morning, everybody. May it please the court. My name is Yana Grishkan, representing the Department of Children and Families. As discussed, I'll take the first 10 minutes, and Attorney Kling, representing the children, will use the final 5 minutes. As you know, this case is about the well-being of two young twin boys. And on this appeal, mother does not challenge any of the underlying facts of the determination that she's not fit to parent the children. Instead, the leading argument on appeal is that the trial court's findings establish no clear and convincing evidence of her unfitness to parent. Mother also challenges the trial court's recitation of the procedural record, as we've already discussed. However, the record and the trial court's decision show that it was supported by an ample record, that it is not clearly erroneous, and that it should be affirmed in full. To begin with, the trial court's decision and the record show that the court engaged in a thorough, detailed review of a mountain of evidence that has now spanned a period of almost a decade. That evidence demonstrates mother's pattern.
What are the facts with respect to whether the mother was at trial?
So the facts that the mother was on trial are based on the docket and the trial transcripts.
Well, your sister says that she was present at virtually all the days. You say, no, the judge is right. She missed a whole bunch of days, including the last one. What we should be able to know the answer is. What's the answer?
Yes, Your Honor. So she missed at least 3 trial dates. The first two were due to medical conditions, and she did not give a heads up either to the court or to her counsel. And the last instance was on, like you said, on the last day of the trial, and she did not show in court and also did not give a heads up, and her counsel was not able to contact her on the last day. So we based that, like I said, on the transcripts and the case docket.
Thank you.
So just to summarize the trial court's findings, first of all, it's very important to note that mother has shown inability to provide specialized medical care that the boys require. And this included not providing them with proper medications, not ensuring that they use medical equipment that was directed by their doctors, and also not taking them to the numerous medical appointments that they needed. Related to this, mother has had a chronic difficulty in keeping herself and her children and her home clean. And this occurred even when the boys were first discharged from the hospital, when they were just a few months old. And at that time, a clean home was medically necessary for them. Contributing to these issues of medical neglect, mother has had a number of mental and physical health issues throughout her life, which we detailed in our brief. So when combined with her neglect of her own health, these health issues contributed to her unfitness to parent. And specifically, I would just note that, despite her serious health issues, mother has shown a pattern of not seeking regular treatment, not following medical advice, and not complying with her necessary medication regimen. In addition to these issues, mother is unable to provide a stable and safe home environment to her children. Her housing situation has been unstable throughout this case, as has her lack of employment. And in particular, we understand that she's not resided in any housing for longer than 2 years, since she, as herself as a young woman, lived with her own grandmother. And the record shows that she was evicted from at least 2 other residencies while the case was pending. Another factor that contributed to her unfitness to parent was a pattern of unstable and abusive relationships. First with father when he was alive, and then with her now estranged or former husband. And with respect to mother's relationship with father in particular, it has involved the repeated allegations of emotional and physical abuse, including when children were at home, restraining orders taken against each other, and ultimately the arrest and incarceration of father for a period of time. And despite these issues, mother has continued her on and off relationship with father up until his death from an overdose during the trial in 2017. As a result of all of these issues, from 2011 to 2015, the boys were removed from their parents' custody on at least 3 occasions. During this time, the department has provided mother, and at that time, father as well, with at least 10 service plans with the goal of reuniting the family. However, the issues continued or exacerbated over the years, as mother's been unable to demonstrate any significant improvement throughout the case. And also, mother participated inconsistently with the various types of support services provided to the family. As a result, the department ultimately changed its plan for the boys to adoption. I'd just like to note briefly here that the trial court did consider the strength of mother's relationship with the boys in judging her unfitness. And although mother visits the boys, she reportedly does not engage with them well or consistently, and they do not appear to share a significant and meaningful bond. By this time, as of today, the boys have been in a pre-adoptive foster home for more than 5 years, and they've reportedly formed a strong bond with their foster parents and call them mommy and daddy. Finally, I'd just like to briefly address.
Can I interrupt
yes.
you for a second? In terms of the judge's findings, those findings, facts 1 through 7, 7, 8, 9, well, 7 and 8, she draws an adverse inference from the mother not being at trial on days before the trial even started. What are we supposed to do with that? Isn't that a sign of inattentiveness?
Thank you, Justice Massing. So I think, as we noted before, there are a number of inconsistencies in the judge's opinion, and I think we would characterize them as scrivener's errors, given how minor they are. I realize that the mother are.
It looks like she cut and pasted paragraphs 1 through 9 from a different case.
I agree that that's what it appears to be the case. Yes. I would just say that these errors are not material in a sense that they do not speak to the substance of the matter. For example, these errors relate to, like you said, incorrect trial dates. There are also some errors in terms of not counting all of the numerous 51A reports that have been filed in this matter. And also another error was confusing the date of father's death from overdose, which happened during trial and not at the end of it. My point is that these mistakes do not undermine the extensive findings of the trial court, which are otherwise apparent in the trial court's decision and the record. And more importantly, there's no argument that these mistakes in any way unfairly prejudice the mother in the matter. So to conclude, I would just say that the trial court findings provide clear and convincing evidence that the mother isn't fit to parent the boys, and that it is in the children's best interest to terminate her parental rights. So for all of these reasons and the reasons that we outline in our brief, we respectfully ask that this court affirm the trial court's decision. And unless there are any questions, I would provide the balance of my time to Attorney Kling.
Seeing none, thank you very much.
Thank you.
Attorney Kling, you may proceed. You'll want to unmute.
Good morning, Your Honors. Attorney Kling, I represent the children, and I also represented them at trial. And I just wanted to clarify one piece that has come up that is, quite frankly, inaccurate from my memory of proceedings. The father actually died after the close of evidence. I had filed a motion to reopen the evidence. There was a stipulation to that effect. And I think then we took additional testimony from a social worker. So that is kind of the sequence of events of how that happened.
Why did you want, I didn't see this motion. I did notice that it was noted. Why did you reopen the evidence? What was the purpose of it?
To get the father's, because literally the father died of an overdose right after we closed the evidence, Your Honor. So we reopened the evidence for that purpose so the court could know, because quite frankly, the only time the mother has ever been able to parent these kids herself is when she has been with the father. You know, when the case came in back in 2011, when the twins were born premature, the parents together as a unit had them for a period of time. But when things went south in that relationship, father ended up in jail. That is when everything went south in terms, and those children were removed. And then that also led to the daughter's removal, who, at least as I can clarify to her as well, at time of trial, had testified that she didn't want to be adopted. By this point, Your Honor, she is an adult.
She was 13 years old at the time, right?
Correct. Now she's an adult, Your Honor. So that is what happened with that child. She came in a different procedural posture, because when the first case was filed, it was about the twins and the premature birth and the need for services. The second case was filed later after the twins removed, and then shortly thereafter, she was removed because of allegations, while in her mother's care only, because of allegations that mom didn't properly administer medication for her, that she didn't seek treatment for her when she threatened to commit suicide with a noose that was made of a jump rope, that she physically abused her with a spoon on her butt till it bled, and that she put a lock on outside of her daughter's door, and that she gave her melatonin and Seroquel to sleep excessive amount. So that is why that case came in. And since that point, Your Honor, She has never been able to regain custody. The only person who was able to regain custody, and it was also brief because of his own concerns, obviously, with drugs, Your Honor, was the father.
The position of the children at trial was that
Terminate
parental rights should be terminated.
Correct. And that's because there is, simply put, Your Honor, at time of trial, and then during trial, the parents were actually on and off too at a number of occasions. In fact, there was some restraining orders flying back and forth there, but eventually, you know, at the time of father's death, they were back again. And, but there was always that constant instability in that relationship, and concerns of abusive conduct by father, concerns of abusive or of substance use by father. It was like a moving target throughout the trial. It was continuously happening. There was new things that came up. This is one of those rare cases for me that there always something was coming up. There was a lot of surprises during trial. But the bottom line is, by herself, Your Honor, she's simply, and I think you can tell by her medical history as well, she's unable to care for herself, let alone her children. While they did have the children in the home, there was a number of services in place for those kids, and you know, special medical care services, visiting nurse, a whole slew of services involved because of their difficulties. And unfortunately, there were problems with hygiene, with the use of helmets that they were supposed to wear, with oxygen monitors. So that even with all those services, including a parent aid, it just couldn't get held together by herself, Your Honor. Now, fast forward, you know, she has her own medical issues that she is on dialysis for, which quite frankly are direct and unfortunate consequence of her inability to address her hypertension, which first started when she was pregnant with her daughter, who's now an adult. So because she wasn't taking her medications, she ended up in stage 4 renal disease. And the only reason that got suddenly treated, Your Honor, was because her own mother made her go to urgent care because she was concerned. She had been hospitalized a number of times up until that point, probably 5 or 6 times. And her mother was like, she's not looking good, let's get her in. So, and even when she got into treatment, she wasn't following those recommendations. And to me, that wasn't unforeseen because of the failure of her to follow her own kids' issues. She didn't follow hers as well. It's a very sad case, but my children are quite content where they are and would ask that you terminate parental rights or pull the termination.
Right. Any further questions from the panel? Seeing none, thank you all for your arguments. And we wish you safety and health, you and yours, in the balance of 2021.
Thank you.
All right, we are live and recording.
Welcome everyone to the February 2nd sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan. Your panel today will consist of me, Justice Gregory Massing, and Justice John Englander. The usual rules of oral argument apply, 15 minutes per side, no rebuttal, and you are welcome to get to the heart of your case, as you can assume that we're familiar with your record. We hope that there will be no technical issues. If they are, we ask for your patience, as we will be patient with you. If for any reason we have a problem that requires a few moments to fix, we may go offline for those of you watching on YouTube, but we will come back on when the problem is resolved. And finally, to both the folks watching on YouTube and to the attorneys who are arguing the case, if you see us for any reason, look away from the screen. We mean no disrespect. We're not being inattentive. We just have our case materials for your case to either side of us, as we would were we on the bench. And we may need to refer to them during your arguments so that we can focus properly on the questions that you've presented to us. So that we'll call the next case, which is 20P0698 FOD LLC versus MASLIN and others. Counsel, you may proceed.
Thank you, Your Honors, and may it please the court. My name is Jason Tallerman, and I represent the defendants in the underlying matter. This matter concerns a claim by the appellees, the plaintiffs, that a certain easement across my client's property will not be overburdened by the construction and operation of a 200-student school. This is the second, well, actually the third, but the second case regarding the easement in particular. The first case established that there was in fact an easement by implication, and not an express easement. And that case also discussed the issue that's before you today, albeit briefly, and the judge ultimately ruled that the question of overburdenment was premature on the basis of the fact that the plans may be modified further. The case then went to the appeals court, which affirmed the land court's judge. And by the way, the land court judge is the same judge that decided the case that's before you here today, and found also on the question of overburdenment that the plans were not concrete enough to issue a decision with respect to overburdenment. So flash forward to around 2017, and the plaintiffs.
Who was the plaintiff in that first case? Was it you guys?
It was the Perillo. It was the predecessors in ownership to my clients.
Right, and this court said overburdening was not pleaded in the complaint, was not addressed at the time the two pretrial conferences, discovery was closed. Couldn't that have been the basis why that decision was made?
It certainly was a basis, but the court went further than that to explain some of the elements that would be required with respect to the plans that were submitted. Some additional details that would be necessary. They needed to know that how much traffic it may generate, how many school buses, how many vehicles it may be, the hours, and the fact that the plans themselves, which were before the court then, may be modified. The appeals court essentially agreed with that on all grounds and said that they needed the plans for construction on the defendant's property to become more concrete before an adjudication could be had. And one of the issues here in this case, Your Honor, is that
I don't think that was the holding of the court. I think what the court was saying is that it could be taken up again once the plans were more concrete and there was expert testimony. There was expert testimony, right? And
there was,
even if they're the same plans, couldn't they have become more concrete in the sense that it was, as the parties had advanced further along, they had determined that those in fact were the plans that they wanted to go forward with?
Well, they were the exact same plans, so they didn't become more concrete. They're the exact same plans. They're actually, Your Honor, jumping ahead a little bit, they're before the Mansfield Planning Board right now, and I'd submit to you that the plans that they've actually submitted to the appeals court are completely different. And as I also note in my reply brief.
First of all, it sounds like you're going outside the record, but are you going outside the record and telling us something that's not in the record?
Only because these issues arose after the filing of all the briefs, Your Honor, and within the last couple of weeks.
Well, but we evaluate what basis would you advance to us as to why we should take into account things that are not in the record? Usually we evaluate what's in the record because that's the only way to determine whether error occurred in the lower court.
And I only reference it anecdotally, Your Honor, because there is ample evidence within the record, including the information noted in my reply brief, to indicate that this project is still not ripe and the plans are no more reliable for future development than they were back in 2013. In fact, the plaintiff's own experts conceded that once they get to the planning board, there's likely to be significant changes. The other witness called, the engineer or surveyor called by the plaintiffs, conceded that significant studies had not been done yet so as to determine whether or not these plans might ultimately be the plans that could move forward at the site plan level. So even without considering the anecdotal evidence regarding the fact that in fact the plans have changed, the information available to the trial court indicated and was clear that these plans were no more concrete than they were in 2013 and were subject to wide variation during the planning board process. So the
Does it matter for your case? I mean, you go a great amount of detail about the battle of the experts. For your case, does it matter if it's 462 trips or 800 trips? I mean, isn't like on the one side there's the kind of trips that a five house subdivision would generate, and the other one there's the type of trips a school would generate. I mean, can't we just ballpark which easement is it? And it doesn't really matter if it's 462 or 800. In either case, you're saying that's too much.
I would say it's too much. What is clear, Your Honor, is that going way back to the time when this project came to light, or when this easement came to light, Ms. Knight, who was the only living person who could speak to the original intent behind it, she was at all times an owner. She's obviously a plaintiff here. Well, she's not the owner any longer in that the sale has been consummated, contemplated 5 house lots. And then she went ahead and submitted a 5 house lot
So
plan.
does that mean that the easement was only for 5 house lots? Is that what your argument is?
Well, I think the touchstone here, Your Honor, is the intent of the parties. And then
Right, and the judge said and found, as a matter of fact, that there were no limitations on the use of the easement.
And
Are you saying that was clear error?
we do believe that that was clear error, Your Honor.
On the basis of what argument? Like why, how is it that we can determine that that was clear error?
Well, because there is clear evidence, and again, it is the plaintiff's burden here, there is clear evidence as to what the intent was by the owner themselves as to what was intended at the time. As to the limitation,
is that the same argument you were just making, that the clear evidence is that what they contemplated was a 5-unit subdivision?
what she contemplated, expressly noted in her testimony, was just a continuation of the subdivision to build a few more houses. There is no evidence to support any other
But the
conclusion.
evidence is that she was not present at any of the negotiations whatsoever.
Well, I'm not sure why presence alone would be a barometer. If she had been present, again, we're talking about an implied easement, not an express easement. So no one ever placed any restrictions on something because no one ever actually granted an easement. It was only implied. So no, and in the case of implied easements, as I referenced in my brief, you have to look at all the intended circumstances regarding intent. Here we have a witness to the issue of intent, the owner of the property who discussed it with her husband. The fact that she wasn't the mouthpiece doesn't make her unknowledgeable about that intent. I'd state also,
That's
Your Honor.
kind of interesting. I mean, did that play out in the evidence at all? Because how does she have any knowledge of what was discussed without it being hearsay?
Well, one, her husband is deceased, but again, her testimony is unrebutted and in the record. And she said clearly that she knew what she and her husband had planned for it. This isn't a question as to what her husband said to Mr. Harris. This is a question as to her intent as an owner.
The difficulty I'm having, counsel, is let's assume that she thought that the plan was for a 5-unit subdivision. Does that necessarily mean that the easement can only be used for a 5-unit subdivision just because that was what the plan was?
No, not at all, Your Honor. In fact, the cases state, the Stack case and other cases state that the intent is the touchstone. And then it is normal development that could occur within the party's expectations and intent. So the frame of reference is the party's intent, but they obviously couldn't consider any other possible thing that may be legal. So if there was another type of development that was consistent with their intent, then that would be allowable. Here, what we do know is that her frame of reference was a small subdivision, but what else could be done on that property? We do know, and it's a key fact that was completely glossed over by the trial court judge and is not referenced at all in my brother's brief, is that this was designed, the subdivision which leads to this, with minor streets in mind. So if Mr. Harris's notations are to be given any credit whatsoever as the person who had dealings with Mr. Knight, he designed a project with minor streets under the town's own subdivision rules, which were in effect way back in '87 when this was done. Under those rules, a maximum of 300 vehicle trips per day would be allowed on this street. So even if we went.
No, that's not right. No, that's the design criteria, that you have a minor street because you're assuming no more than 300 trips. But nobody's sitting there counting cars saying that you can't have more than 300 cars come across. It's a public way, right?
Well, yes, but again, we're forming the basis of what would be normal development within the framework of the intent. If Mr. Harris did intend to leave this wide open, or if the Knights intended to do something that would exceed 300 vehicle trips, then the planning board itself would have required, and Mr. Harris would have had to have designed the roads to a secondary street standard. He did not. So when you're looking at what could be normal development with respect to the party's intent, they themselves contemplated that the subdivision design would have only a certain carrying capacity.
What's the source of the design? Sorry, go ahead.
Go ahead. There is then a tension, according to you, between the judge's findings regarding the scope of the easement and the primary and secondary street. But returning to the judge's findings, which he made based on the testimony of Mr. Knight in the previous case, are you claiming that those findings, that the easement was unlimited in scope, were clearly erroneous?
We believe that his findings were clearly erroneous on almost all the factual circumstances.
Well, just on that matter, and if so, are you basing that solely on the testimony of Mrs. Knight or anything else?
Well, we have the testimony of Mrs. Knight, and that is clear. We have also the testimony that the judge himself elicited from Mr. Harris, which we believe to be taken out of context. And in fact, as we note in our brief, Mr. Harris actually does reference, in fact, that it would be used to further subdivide the property. Now, he developed a subdivision. So to further subdivide the property connotes that it would be additional subdivision.
Right.
We also
there is an additional subdivision. It divided the property. Mrs. Knight has part of it and the other part's going to FOD. That's a subdivision.
No, it's not, Your Honor, actually.
Why not?
They're not subdividing the property.
That's not a subdivision. Why? Because there's enough frontage?
No, because she's got a life estate with respect to the property, but they're not dividing the lot up any further. If you have a Dover Amendment use, you could add a Dover Amendment use to an existing lot without violating
Maybe I'm misunderstanding, counsel, but I thought that 13.7 acres on which Mrs. Knight had a property was one lot, and that part of that lot has now been sold to FOD.
That's not correct, Your Honor. All of it has been sold to FOD.
Oh, I see. And she has a life estate on her part?
Correct, Your Honor.
And there has been no division of the property?
There has been none, and no division, to my knowledge, has been proposed.
Are you saying, though, that the primary and secondary street factors are also a reason for questioning whether or not the judge's findings were clearly erroneous, or is that a separate analysis?
Well, it's certainly related to that issue, Your Honor, because if the judge had given credence to that particular fact, then his whole analysis regarding what would constitute normal development within the frame of reference of the original party's intention falls apart. So if he's suggesting that it was wide open and there was no limitations whatsoever, he has failed to recognize a key fact.
He clearly says that's not the case. He cites the law that says it's not unlimited. There are limitations. And he's trying to figure out what's normal, right?
Right, but then he concludes that there were no limitations here, and we contend quite clearly there were, both with respect to the original party's notions, as well as what the planning board said, as well as the
So help me with that. 15 units would have been okay or not?
I think our case on 15 units would not be viable, Your Honor. If they came in with a 15.
Suppose we do a 40B and instead we go with 40 units. Is that okay?
Well, as someone who does 40B work every day, Your Honor, I would cite that 40B is actually well beyond the scope of what is normal development. The 40B statute is designed to be an exception to what is normal development and to essentially have no limit to what could be proposed if in fact the give back is affordable units.
Well,
it is an exception.
Where are you getting the word so you're now equating the word normal with what town bylaws, zoning bylaws would ordinarily allow?
Town zoning bylaws as well as subdivision regulations. Yes, Your Honor.
But what is it in the case law that tells me that that's how this is the word that's in the law, normal, right? That tells me that that's what normal means.
Well, again, I would submit that the term normal is only, if you look at the cases, they don't break, it's not one or the other. The term normal is still with a frame of reference to the party's intentions. I looked, Your Honor, for anything regarding whether Dover Amendment or Chapter 40B had ever come up in the context of assessing it as normal or abnormal. There is no case law out there on that principle. As a municipal lawyer, I submit that these statutes exist as a remedy against normal, because there is no measuring stick except for reasonable regulation for Dover Amendment uses. And under Chapter 40B, we know that small lots can blow apart density limitations with respect to.
Okay.
But what we do.
Well, our time has expired. Any other questions from the panel?
I have another question, yes. On this, and actually it was relevant to what you're just saying. The 40B allows, and the Dover Amendment for that matter, allows you to forego some of the normal zoning limitations. And I want you to focus on 40B. Would that allow you to blow over an easement restriction?
Absolutely not, Your Honor. And I was just going to say, before Justice Sullivan spoke, that there's in fact cases, a very important Groton case and their progeny, the Washington Green case out of Groton, which say that 40B can waive a great number of things, but what 40B cannot waive is property rights on there, so that they could not touch the easement or waive the easement under 40B.
Thank you.
Okay. Any other questions? All right. Thank you very much. Attorney Lonza, you may go forward, and if necessary, we'll give you equal time.
I think I'm unmuted now. Can you hear me?
Yes.
Good afternoon, Your Honors. Mark Lonza for the plaintiffs' appellees in this case, FOD LLC and Brendan Knight. I'd like to start off by addressing this issue about whether the plans were concrete enough in order for the land court to deny the defendant's motion to dismiss on the grounds of lack of ripeness. When the plans were prepared at that point in time, and we're talking about sometime in late 2017, they weren't just the site plan that was at issue in the easement case, that is the Perillo case, which was actually reviewed by this court. In addition to that, and this is all in the record, and if it's not in the record, it's referenced in the record, there were also architectural plans, multiple plans showing and sketches showing what the building would look like, how high it would be, the floor area, that was included. Most significantly, since easement overburdening issue is the central issue in the case, we anticipated that there would be need for a study, a traffic study by a traffic engineer. That too was presented to the land court at the time in late 2017 in opposition to the defendant's motion to dismiss for lack of subject matter jurisdiction based on ripeness. So, and the only thing that wasn't presented that the Judge Long said was needed would be a queuing study to show that when the people with children were dropped off and picked up, the vehicles wouldn't back up, line up and queue up and back up into a public way in front of the defendant's homes. That was provided in February of 2018. As of that point in time, We had submitted everything that the court would need to make a decision. Now, Judge Long was careful to say, you do understand, don't you, that if you go forward and I make a decision as to whether or not the proposed facility in the plans and the traffic study does not or does overburden the easement, you're stuck with that. You can't change it from 200 enrollees to 300 enrollees, because now you don't have a decision from the land court establishing that that level of use is not overburdening the easement. So that's what my clients have done. Now there's a reference by my brother to a plan before the planning board. I think if he could address it, I'd like to take 30 seconds to address it. There is a plan before the plan, a site plan before the Mansfield Planning Board, but it's not this project. It is a temporary building to provide some school space, some facility space for the current applicant to expand a little bit while the main project, the project that's at issue in this case, and has been at issue in the Perello case and one other case, the Ellsworth case, is being developed. So
can we it's not useful to go outside the record, I don't think.
Okay.
Let's go back inside the record. Okay. It seems to me that the key issue that was before the judge and on which he ruled in your favor is whether the school is quote unquote normal development of this easement or normal development as to which the easement will access it. Where can you give me some help on trying to determine what the word normal means? Because a school with 200 students and 600 or 800 cars a day does seem quite different than a subdivision, even if it's as many as 20 homes on 13 acres.
Well, as the trial judge ruled and in his decision said, you have to look at what could have been developed, what could have been developed on the property at the time the easement was created. Again, we're not dealing with a 2-lot piece of property. We're dealing with a 14-acre piece of land. You could have a substantial amount of development on that piece of land. In fact, even a conventional residential development, if the road could be extended, you could put a lot of lots and a lot of houses in there to generate a lot of traffic 365 days of the year. Keep in mind that this facility generates traffic less than 180 days a year. So if you ask
really, you could put a lot of lots in. What's the zoning? What's the how much do you need in terms of lot size?
I think we're in a 1-acre zone here.
Okay, so you're talking about, unless you go 40B, you're talking about 13 lots, right?
Correct.
Okay, that's going to be a good bit different than 600 trips a day.
Well, again, looking at it in an entire year, it might not be all that different. The traffic studies show that the current subdivision with fewer homes than that generates 200 trips a day. So if you add 10, 12, 13 homes, it could, and 365 days a year, that's a lot of vehicle trips total in a year versus a school or a facility like this with by the way, it's a maximum enrollment of 200. I mean, on an average day.
And how does that maximum enrollment, how does that compare to the current enrollment? Is it about 1.5 times?
Yes, it's about that. And the current enrollment is at a different location, a much smaller facility, a much smaller piece of land. But it's an interesting question because
sorry to keep interrupting you, Mr. Lanza. I apologize.
The issue of normal development usually comes up in the context, in all the cases I've seen, of some sort of residential development. I have another easement overburden case in the land court, and that's exactly what the issue is. Will an additional house lot, make the easement or result in overburdening of the easement? I have not seen any cases, as my brother has not seen any, that deal with the issue of whether or not what is allowed under state law as a matter of right, which overrides local zoning, can be considered normal development.
So there's so the judge says, it seems to me, and maybe the key passage of his opinion, when there is no express limitation, an easement is available for the reasonable purposes to which the dominant estate may be devoted. these reasonable purposes include a private Montessori elementary school of the size proposed here. Is that a question of fact?
I think, yeah, absolutely, it's a question of fact. But I have to say there is some law, because then you have to ask yourself, well, first of all, did the parties contemplate something like that? That's a question of fact. Okay, we know that Mr. Harris and Mr. Knight, both of whom are deceased, by the way, when they negotiated the easement, clearly placed no limitation on it. So you have to ask yourself, if there's no limitation, well, was this one of the potential uses that they contemplated? But then I think you have to ask yourself, what is allowed by law? And that means both local law and state law, because you're not going to, I don't think anybody.
You could have something that was, given the nature of the access points, the nature of the property itself, was unreasonable, couldn't you? Even if it was something that in theory could be built there. A 40B with 200 units might be unreasonable even if it could somehow be permitted. Or am I missing the point? And I really want to get back to this question. Is this a question of fact? Did the judge make this as a finding of fact? And if so, what standard did he use?
It was a finding of fact. I don't recall, in fact, I know it was not a ruling of law, but certainly law had some influence, I think, on the finding. So in order to reverse it, there would have to be evidence in the record that Judge Long was clearly erroneous, and there's no such evidence in the record. In fact, the evidence, I think, militates in the opposite direction, that you have a huge, I shouldn't say huge, a very large piece of land, 14 acres, and you have a use that's allowed by right, by state law on that land, and that's what my clients are proposing to do. And there's no evidence anywhere that the people who created the easement had in mind a limitation that would preclude that. And that's what it would take.
What do we do with the fact of the primary versus secondary road argument? How does that factor into the judge's finding? And should we consider that in determining whether or not the judge's finding, if it is indeed a finding, was clearly erroneous?
In my view, that shouldn't be considered. That's beyond the scope of this case and the issues in this case. The issue in this case is the proposed use of the property for up to a 200 enrollee childcare facility with elementary educational use. Will that overburden the easement? Okay? And we're focused on the easement. The easement area is a very narrow, small piece of land that crosses the defendant's properties. The public ways in the subdivision, again, yeah, they were designed, perhaps they were designed to a particular standard called a local street. But as Justice Inglander noted in response to Attorney Talaman's argument, there are no limits on how many vehicles can cross over that street in a day. There's no sign, there's evidence that there were signs on the street saying only 200 cars a day, or only 800 cars a day.
Was this, to the extent that this argument may or may not be relevant to what the intent of the parties was at the time the scope of the easement was negotiated, and I understand your position on that in the judge's finding, but just as a technical point, was this question about the local roadway raised at trial with respect to the party's intent?
It was not raised, to my recollection, at the easement trial. It was during the easement trial in the Perillo case that the issues of, does the easement exist? Does it exist to its full width? And are there any limitations on it? Are there any limitations or restrictions on what it can be used for?
Was it raised in this case?
I believe it was argued in this case, yes, even though it was already decided in the Perillo case.
But I take it your argument is that the time to have raised it was in the Perillo case and it's too late now.
Yes, we're dealing with the scope of the easement. Now, again, the issue here is—
wait a second, counsel. So although you're, of course, correct that it's a public way and it's not limited to 300 cars a day, when you're trying to evaluate what is normal use of the dominant estate, why isn't it relevant what access was designed for in trying to determine what the parties thought was normal use?
In my view,
Yeah.
that was something that solely between the developer and the planning board to determine what sort of road should be, built in that subdivision for the proposed lots and houses. I don't think any consideration was given to what would exist, if anything, beyond the end of the subdivision across the easement on my client's land.
Well, but of course they're considering what's going to happen to the 14 acres that otherwise are landlocked. That's why they're saying you need to put an easement on the plans. Of course they're aware that there's going to be development behind there, right?
Yes, but no discussion about what type of development is evident in the record of the planning board's proceedings.
But if the planning board is approving roads that are built for, let's just back up for a second. Is your brother correct that there's criteria in, I'm taking it to be the subdivision control or the subdivision rules of Mansfield that say minor streets designed for 300 cars a day. Is that right?
That's correct.
Okay, and that was the case when the easement was granted. I can't remember the year of that right now, but that was the case when the easement was granted, right?
Yes.
Okay.
But there's no evidence, any thought was given to what the property on over the easement, at the other end of the easement, past the cul-de-sac, would be used for. There's absolutely nothing in the record in any of the cases that have gone through the land court that suggest that was a consideration by the planning board. I suppose it could have been, but there's no evidence that it was, and that's what's key here. I'm just if I can come back to the ripeness argument for a minute. Again, the defendants argue here and assert, that the case was not ripe for just review because my clients had not obtained permits, all the permits and approval they need for the project. And therefore, they had to do that before they could ask the land court for determination as to whether or not the easement would be overburdened by the project. But the issues are very different. One involves whether or not my clients have sufficient property rights to use the easement for the intended purpose. This court and other appellate courts have ruled sufficiency of property rights, whether they exist or not, are beyond the scope of the authority of the planning board in the subdivision review process. The site plan approval that's needed, as this court and other appellate courts in Massachusetts have consistently ruled, is not a sort of approval that is a process that can be used to deny the project. The purpose is to determine whether or not the project can be built subject to reasonable rules and regulations, and those rules and regulations are limited in Chapter 48, Section 3, paragraphs 2 and 3. At present, my client's project complies with every rule and regulation of the town of Mansfield for the project, zoning, except for frontage, and we have an unappealed ruling from Judge Long in the Ellsworth case that it need not comply with frontage. The only other issue that hasn't been addressed is parking. And certainly with 14 acres, there's enough land there for parking for the facility. The regulation.
Can I ask a question about this? This is related. So the Judge Long finds, based on the traffic report, that the property, the design, or it could be redesigned, it's going to be able to accommodate the traffic. It's not going to back up into the street. If we were to affirm that this sort of this future overburdening finding, and lo and behold, the school is built, and it comes out that there are cars backing up into the street all the time. It's going all back onto the main road. It's going back on. Could the neighbors then come back and say, now you're overburdening?
I don't know. They couldn't come back and say, now you're overburdening. However, the town has ample authority to regulate what goes on in the public way.
Why couldn't they come back and say the facts have changed? The facts that you presented were you're going to have 6 cars in a queue. It turns out you got 40, and they're sitting there by our house 3 hours a day. That seems to me to be a changed fact that would allow them to bring that suit.
Perhaps, but I would think it would be res judicata, and the town would address the problem and require my clients to address the problem.
Yeah, I mean, I don't think so. And the reason I don't think so is because I think those are changed circumstances, because that's the whole point that your brother is making, that you have to, this DJ has to be on the facts as you presented them. And if there are different facts, it's not going to be res judicata. That's my take anyway.
Perhaps. And let's hope that day never comes. We've had 3 cases so far, and I'm trying to avoid a 4th one. Unless the justices have any other questions for me, I rest on my brief and appreciate having the extra time to be heard.
Any further questions, anyone? Seeing none, thank you both for your arguments, and we wish you, for the balance of 2021, for you and for your families, a safe.
All right, we are live and recording.
Thank you very much. Welcome to the February 2nd sitting of the Massachusetts Appeals Court. This is our 6th and final case. My name is Mary Thomas Sullivan, and your panel today will consist of me, Justice Gregory Massing, and Justice John Englander. We will follow all the usual rules of oral argument. Each side will get 15 minutes, and there will be no rebuttal. We hope that there will be no technical issues. If they are, bear with us. We will do our best to resolve them. If you will be patient with us, we will be patient with you. And to those of you watching this on YouTube, if we do have a technical problem requiring it, we may go offline momentarily, but please be patient with us. We will come back. And finally, you may note from time to time that we may look away. We are not inattentive to your argument. It's simply that our paperwork or our iPads are to one side of the desk or another. You have our full attention. We are listening, and we mean no disrespect. In fact, we're simply trying to follow along as best we can with your argument by making our references to the record as we would if we were sitting in a physical courtroom. So with that, we'll call the last case, which is 20P0480, John Doe number 524065 versus Sex Offender Registry Board. And I'll remind the parties that this is an impounded case and that pseudonyms are required. And with that, Attorney Combs, you may proceed.
Thank you. Good afternoon, Your Honors. May it please the court, Matthew Coes on behalf of John Doe. John Doe's classification as a level 2 moderate risk sex offender must be vacated for 3 specific reasons. First, the hearing examiner did not have objectively adequate reasons for giving the expert evidence limited weight. Second, the hearing examiner committed error by failing to properly weigh the Hansen transcript and the other evidence regarding the repetitive and compulsive risk factor. And third, SWORD failed to meet its burden of proof by clear and convincing evidence that Doe was a moderate risk to sexually reoffend, a moderate degree of sexual dangerousness, and that internet publication of his personal information was necessary. I want to address all 3 of these arguments today, but I want to start with the first argument regarding the expert evidence. In the Doe...
Before you do, just so that I can orient myself as I listen to you, is it fair to say that with respect to this argument and the one that follows about factor 2, that you are making only an as-applied challenge and that you are not challenging the regulations on their face?
No, I'm not, Your Honor. I think the argument, and I'll get into this a little bit more detail when I get to the factor 2 argument, but I think that this argument that I'm making falls in line with the Doe 151564 case and the 205614 case, where the Supreme Judicial Court said it was okay for the hearing examiners to look at evidence regarding sex offender recidivism that was not specifically accounted for in the regulations. I do recognize that this is a little bit more of a nuance argument because the regulations do account for repetitive and compulsive behavior, but I would suggest that what the relevant scientific community in this particular case is saying is different from what the regulations does. So on the one hand, you have the board saying that multiple instances of sexually offending conduct is indicative of a high risk to reoffend. And then you have Dr. Hansen, who is one of the board's authorities, who is saying that it has no predictive value whatsoever. I do think that the regulation can stand even if, in this particular case, the hearing examiner were to find, or this court were to find, that Doe's behavior was not repetitive.
The board doesn't have to follow what Hansen says, right?
It's not required to follow everything that Hansen says, Your Honor.
Not required to follow anything that Hansen says.
Well, I think that they have to be informed by the scientific research that they cite in the regulations.
Right.
And with respect to factor 2, both of those regulations both of the scientific articles cited in that regulation were written by Dr. Hansen.
Sure, and he's an authority in the field, and he's done more research than a lot of people. But this particular issue is whether it is predictive of future repetitive, or I'm thinking the word recidivism, but it's not the right word under the reg. He's saying it's not predictive that they've engaged in multiple instances of sexually incorrect behavior if they haven't been caught, right? And does the board have to accept that?
Well, I think the court should accept it because, again, Dr. Hansen is one of the board's authorities.
Really? Even if it seems to be entirely counterintuitive with what other folks, what we know as human beings about behavior? He's done a study, and this is what his study has determined, but the board is not free to disregard that?
Well, not if the regulation should adhere to the science as it stands. And so what we have here is we have Dr. Hansen's testimony. We have the article, which is cited in the regulation, which I would suggest is inconsistent with SORB's regulation. And then you also have Mr. Keating's testimony. Mr. Keating said that Doe's behavior was not compulsive. And I didn't cite it in my brief, but in preparation, I recognized on cross-examination, the board's attorney asked Mr. Keating whether or not the multiple instances of sexual misconduct were indicative of compulsive behavior. And he suggested that they were not. That's on page 533 and 534 of the record. So here we have an overwhelming amount of evidence, in my opinion. Dr. Hansen's transcript, the Mr. Keating's testimony, the article that's cited in the regulations, and the way that the static 99 actuarial tool is scored when you're looking at index offense. Dr. Hansen kind of gives the analogy to speeding. A lot of people speed, but their conduct tends to change once they've been pulled over or confronted about that behavior. And the same holds true with respect to sexual offending. When you read the static 99 coding rules from 2003, it basically suggests that if there's 50 incidences of sexual misconduct or one incidence of misconduct, on the static 99, it's scored as one sex offense called an index cluster. And so when you're predicting future risk, That is the key component. That is what is
That
important.
sounds to me to be an argument that static 99 should be taken as setting the standard for how one determines what is repetitive or compulsive. Is that what you're arguing?
Well, in essence, I guess that would be kind of a byproduct of my argument, Your Honor. I would suggest that, the static 99 is very frequently used. It's cited in the regulations as an authority, and the way that the static 99, as a result, certainly is relevant to the board's consideration when it tries to predict future reoffense.
What do you say on the substance of Attorney Bossie's argument that the AASI test that was done by the expert is not, I don't know what not a reliable test? I understand the procedural argument, which is this was not raised before the hearing examiner, but what do you say on the substance? Because the case that he cites is 15 years old.
That's correct, Your Honor. That was going to be my argument. First of all, this is an old case, and we don't know if the AASI is still viewed in the same manner as it is now by the scientific community. We also have the expert, Mr. Keating, who said that the AASI or the ABLE was generally used in this particular community. And so again, that wasn't challenged at all at the hearing. There was no reason to believe that it wasn't. The hearing examiner seemed to accept that it was generally accepted in the scientific community. And certainly Mr. Keating has 20 years of experience. He's worked for the courts. He's also done this privately. And so it's something that informs him. It is not the complete substance of how he formed his opinion. It's merely one component of kind of a constellation of considerations that he made with respect to Doe's risk.
What do you think? So I think I understand your argument for why your client should be a level 1. But I have to say that I'm stuck on the standard of review because a fair amount of your argument seems to me to be arguing the weighing and balancing of evidence. What do you think is your best argument for how we can overturn a level 2 adjudication here?
Well, I think it goes to the risk of reoffense. So the board needs to prove their case on all 3 elements: risk of reoffense, degree of dangerousness, and internet dissemination based upon the Doe 496501 case. I believe that the Doe's best argument in this respect is the risk of reoffense component. First of all, we have Doe. The hearing examiner identifies him as what's called a solicitation offender. And when you look at the Hansen transcript and what Dr. Hansen said, he puts solicitation offenders in a subset of sex offenders that, in his words, recidivate less than 5% of the time. So there's a 95% chance that Doe, from a statistical standpoint, would not reoffend. And that's far below the average. In the Doe 380316 case, it cited a study that said the average risk of reoffense, which was a Hansen, was at 11.9%. So we put him below.
Let me ask another question along those lines, though. I mean, that entire argument assumes that Doe is a non-contact offender. The police report actually identified contact offenses. multiple contact offenses, which the hearing examiner then said, I don't think, because this is third level hearsay, that there's enough here for me to do that, to find that, or words to that effect. Do we, in evaluating the hearing examiner's determination, do we have to consider this person to be a non-contact offender despite the evidence that was in the record to the contrary?
Well, I don't think that there is reliable evidence to conclude otherwise. Again, as Your Honor noted, the police report is third level hearsay.
But he admitted to a whole lot of the stuff that was in that third level hearsay. And certainly if someone had determined that they felt that the contact portions of that was reliable, it would have been very hard to overturn it because he admitted to much of it.
I would disagree that, in terms of the contact offenses that she alleged, I don't think that he admitted to.
No, he didn't admit to the contact. Well, he admitted to the peck on the, he admitted to the kissing.
That's correct.
But he did admit to so much of the other description that, one could say, well, given that your client has corroborated much of what was reported in that third level hearsay, one could infer that the remainder of it was also true. Now, I understand we run up against this issue that the hearing examiner himself said not enough. But I was asking the question really, as a reviewing court, are we stuck with that? We must look at him as a non-contact offender.
Well, I think the case law is quite clear that the reviewing court should give deference to the sort of hearing examiner and their knowledge and expertise in this particular area. I think that the hearing examiner's findings of fact on that particular point were sound, given the third level hearsay, the fact that he was not even charged in the Superior Court with a contact offense. And I would also suggest that his testimony, the fact that he readily admitted and conceded that he had done some of the conduct that for which he was convicted, certainly gives a certain credibility to that as well.
I have another question for you, and this goes back to factor 2. If we were to decide, and I'm not saying we would, that factor 2 should have been treated differently, how would we know whether the hearing examiner would or would not have reached the same conclusion, regardless of her findings with respect to factor 2? She relied on 3 grounds.
Right. So factor 2 is considered a high risk factor, which as the factor says, it's indicative of a high risk
on another high risk factor as well.
Correct. So she found factor 2 and factor 3. So even if you apply factor 2 and then you were to apply factor 3 couldn't be given the full amount of weight either. So under both factor 2 and factor 3, those risk factors can only really be given a threshold amount of weight. So I would suggest that if you remove one entire of the high risk factors from the equation, I would believe that it would move the needle towards a level 1 as opposed to a level 2.
If we were to say, and again, I'm not saying we would, that this case required a remand, what would the procedure be? We're now 5 years from the original evidentiary hearing.
Well, I think it's up to the appeals court what the proper remedy would be. In some instances, the appeals court or the Supreme Judicial Court has ordered a rehearing.
What is your opinion as to remedy? What do you think the remedy should be in this case?
I think given the amount of time this case has been pending, it's been pending since 2016. There's certainly been a number of factors that could go either before or against Doe. And I think the case law also suggests that the public interest and the offender's interest are both served by having an accurate and up-to-date classification. So I would suggest to the court that if this case were to be remanded, Doe should be entitled to a new hearing so that an accurate classification could be issued.
Does anyone else have any other questions? We've run a little over, but it's a difficult case. Okay. Thank you very much. Attorney Bassett.
Good afternoon, Justice Sullivan, and good afternoon, Justice Massing, Justice Englander. May it please the court, John Bassett for the Sex Offender Registry Board. I'll first address Factor 2, whether the hearing examiner properly applied Factor 2. And I should note that in 2019, this court, in a published decision, found that Dr. Hansen's testimony from 2014 was relevant and that the hearing examiner should consider Factor 2, but this court did not give an opinion on what weight, if any, should be given to Dr. Hansen's prior testimony from 2014. As a result, I submit that the hearing examiner, as she wrote, she did consider the transcript of containing Dr. Hansen's testimony, but she properly found that she had to apply Factor 2 based upon how SORB defines repetitive and compulsive behavior. And as a result, based upon how SORB defines repetitive and compulsive behavior, she properly applied Factor 2, and she properly applied only moderate rate to Factor 2 because there was no evidence that Doe continued to engage in sexual misconduct after he was confronted by the people who he was employed with.
Does she have discretion not to apply?
Excuse me, what was that?
Does she have discretion not to apply Factor 2 where there are multiple events? With one?
Certainly, I would say that if she chose not to apply it, then she could. That would only.
She doesn't have to apply Factor 2 each and every time she's confronted with a sex offender where there's evidence of multiple events separated in time, does she?
No, she does not. I don't see a reason why, if the facts support the application of the factor, I don't see why the examiner wouldn't apply it, but certainly they have discretion to
maybe because
not
the
apply
facts
a factor.
don't mean either the word repetitive or the word compulsive. Anyway, I think that's beside the point for today's discussion.
With respect to the issue of compulsivity, and as you know from the case you just cited, there was a concurrence in that case. So let's focus on compulsivity for a minute, if that's the way you pronounce it. Is there any research paper cited in the regulations, any of the regulations, or provided to the hearing officer in this record that would support a finding that repetition over time with the opportunity to reflect is evidence of compulsive behavior?
No, Your Honor, and I'm glad you brought up that question because Attorney Coase and I are currently litigating a case in Middlesex Superior Court where Attorney Coase and his client are seeking to declare Factor 2 as unconstitutional. And although SORB's Factor 2 cites to 2 scientific studies, there's no scientific study that supports how SORB defines repetitive and compulsive behavior. And our argument is that, and I cite to a few cases in my brief, is that legal definitions need not mirror medical definitions. So that's SORB's argument, is that there's no scientific studies to support how we define repetitive and compulsive But
The
under
compulsive
decisional
part.
law, what was that?
There's no study to support the compulsive part. The repetitive is probably self-explanatory. Could you, in a 16L letter, just send us the Superior Court docket number for that case?
Sure.
I take it we can all agree that we don't have that constitutional issue before us, and that this is not an on its face challenge.
Yes, Your Honor, and
Oh.
I apologize for not putting the docket number for the Middlesex case in my brief, but I did have it. I do have it if you would like me to recite it.
Sure.
So the docket number is 2081 CV 01130, and that's out of Middlesex Superior Court. Attorney Coase and I are litigating it, and we expect to have a hearing on motion for judgment on the pleadings in the near future.
Okay, so that will be an interesting case, which someone will see one day. But as to this one, which is also very interesting, if there is no scientific study which supports the notion that that the regulation itself can stand for the proposition that behavior is compulsive if there's an opportunity to reflect. If there's no scientific study for that, from whence does the regulation derive its legitimacy? And I would ask you to answer that question in the context of the SJC cases, which discuss the regulations based on sex and the legitimacy of those. I mean, the SJC clearly cast doubt on the male-only aspect of the regulations and asked the board to recalibrate its regulations. So where does the legitimacy of that first level of factor one come from, in your view?
Well, I believe it just comes from a common sense view that if there's evidence that an offender had the time or opportunity to reflect on their sexual misconduct, very serious offenses, and yet they continue to do it, I think then that meets the dictionary definition of compulsive, and that they're unable to control their sexual misconduct. So it's more of a common sense argument. And I know in one case in 2006, the Supreme Judicial Court explained that the sexual misconduct was repetitive and compulsive because the offender on one instance engaged in sexual misconduct and then thereafter engaged in another instance of sexual misconduct.
What's your
Whoa. I'm sorry, go ahead. Sorry, Judge Sullivan.
Go ahead, Judge Englander.
Well, there's an SJC case that says that two different activities of sexual misconduct is necessarily compulsive?
No, so in that case, they said factor two applied. They said repetitive and compulsive behavior applied because the offender committed an act of sexual misconduct on one day, and then thereafter committed another act of sexual misconduct. In that case, I'll just say
all they did was say that in the facts of that case, it was sufficient to apply factor two.
Exactly.
For example, if somebody engaged in a rape with a particular type of circumstance and then did that again, I don't know, 6 months or a year later, you could conclude that that was compulsive. But that doesn't mean that every time you have two events separated in time, they are compulsive. There has to be something that the word has meaning, and it ought to be applied with meaning so that you don't just check a box and say, well, that satisfies compulsive because they're two different acts of sexual misconduct.
Yeah, and Justice Englander, I'm really happy with these questions from both yourself and Justice Sullivan because you're raising great questions, and Justice Milkey in his concurrent opinion wrote, I thought, a very thoughtful concurrent opinion. It's just that, the the board is saying from a common sense view, not from a scientific view. Because I know of I've spoken to a few of the board members who are psychologists, and I said,
let's not go outside the record, all right?
Okay.
Yeah, let's stay out.
Let's stay with the record. So
Let's stay
here's my
inside.
concern. I'd like to play this out. I understand your argument, whether it applies in this case or the multiple rape case. You know, we could talk about that for a very long time. But we also have a doctrine that says that the hearing examiner is free to reject the expert opinion of this doe or any other doe because the regulations are considered to be grounded, scientifically based, and otherwise legitimate. And if we take the scientific basis out of the regulation, how do we then say that the hearing examiner is entitled to rely on these regulations as their Bible, for all intents and purposes, to the exclusion of all other evidence? How do we have faith in a system that permits that if we can't legitimate the regulation to start with?
Well, I think you have to go with decisional law, that a regulation has the force of law, and as a result, the hearing examiner has to apply the regulation as written, and deference should be given to.
But that assumes its conclusion. I'm totally with you. If the regulation is valid, we defer to it, but it has to be consistent with the statute. And under Justice Lank's decision in the case involving male and female offenders, it can't be circular. It has to be grounded.
Right.
So what's your best case, legal case, for the proposition that the board's common sense understanding is sufficient to inform the regulation?
Sure, Your Honor, and I do cite to the United States Supreme Court case in my brief of Kansas versus Hendricks, in which the court said that legal definitions need not mirror those by the medical profession. And I cite
That's the converse of the question that Judge Sullivan is asking you. The fact that they don't have to doesn't answer the question of what is a sufficient basis. She's saying find a case that says you don't have to have, that common sense is enough.
Oh, I would submit those two cases that I rely upon show that common sense is enough, that a legal definition need not mirror those advanced by the medical profession. And
they have to have a reason. It's not enough to say they don't have to follow medical. They have to have a reason for not following medical. They have to have a reason for why they chose their particular regulation, right?
But also the other cases that I cite, that the Reverse versus Chelsea Housing Authority, they said deference should be given to how an agency defines their terms.
That is circular. I'm sorry, counsel. That's just flat out circular. We should approve it because your client has said it. No, your client has to have a basis. There has to be a reasoned basis. And if it's not going to be science, what is it? And how do we know that what it is sufficient?
Mm-hmm. And I understand, Your Honor, and to me, it's a common sense argument that if there's evidence that the offender had the time or opportunity to reflect on their misconduct and they continue to do that, then that matches with how
that can be evidence of compulsivity. Can I ask a slightly different question, Judge Sullivan, or are you?
Oh, I'm all set. Thank you.
Thank you.
So there's very powerful expert opinion in this case from someone who, I take it from his testimony, is not someone who always testifies on behalf of sex offenders. And that very powerful evidence is, I spoke to this person I looked at this person's record. This person has an extraordinarily low risk of reoffense. And the examiner rejects that, as they have to, with some specifics, two of which you concede are incorrect on the record. What are we supposed to do with that? Because it seems to me that if the expert supports Doe's position and your hearing examiner has to reject that reasonably, and two of the examiner's reasons, in fact, the principal reasons given for rejecting, are incorrect, to me, I seem to be left with the expert opinion.
Right. So, and I conceded that the hearing examiner incorrectly found that Keating did not remember two of the sex offenses that Doe was convicted of, when in fact Keating testified that he did not remember that the offender was also convicted of posing or exhibiting a child in the state of nudity. So the fact that he actually forgot that the offender was convicted of 3 sex offenses, it's relevant as to the amount of attention and detail that Mr. Keating gave to the expert opinion.
Well, what the examiner said is Mr. Keating was not familiar with the petitioner's other 2 convictions.
Right.
And as I read Keating's cross-examination, he was familiar with all of them. He just couldn't remember what one of them was.
Right.
He testified unequivocally, I asked about all of those offenses and what the bases were. So isn't that that's just wrong, that statement by the hearing examiner, right?
Yeah, and I conceded to that, but on
you seem to be suggesting that he was only half wrong, and I'm suggesting to you he was fully wrong.
Right. I understand, but I think how it played out was that when Keating testified, he did that on cross-examination. He said to the sword attorney, "I can't remember what the other offense was. Just tell me." And then later on, Keating testified, but I did review his entire query with him, and I'm familiar with all his sex offenses. I think that's the hearing examiner brought that up. I thought that was a little too much. My main argument about the treatment of
and I thank you for your candor.
Yeah, no, I think it's a little nitpicky. But my main concern with Keating's testimony is that he's relying upon the ABLE assessment, which when you review Keating's testimony, it doesn't seem like the test has changed significantly since this court.
Well, wouldn't one of the most important factors be whether it has become accepted in the field over the last 15 years or whatever it is? I mean, that's what we don't have any evidence on, and the issue was not raised by your folks below. And we have a case that just came out recently that says it's not really appropriate to rely on an argument you make now that wasn't made before the hearing examiner, right?
And you're right, Justice Englander. The reason why I thought I could make the argument is because Keating explained what the test is, the ABLE assessment is, and then if you look at the In re Reedy case, this court went into great detail about what the ABLE.
But Reedy refers to the ASI case, not the ASI test, not the ASI 3. And we don't know whether that instrument has been altered since the case was heard. We don't know anything. We don't have a record.
Fair point, Justice Sullivan. Thank you.
If I may, if this case, and I'm not saying it would be, if this case were remanded, what do you think the remedy should be, and should there be a hearing?
Sure, Your Honor. I agree with Attorney Coase that if this court remands it, the offender should receive a de novo hearing, and it really makes sense to give him a de novo hearing because every 3 years from the final classification, offenders are receiving a de novo hearing if they request it. But generally with the remand, it's a de novo hearing. And and if I could just add one more thing, I appreciate the panel's questions about factor 2, and hopefully we'll get some more answers about factor 2 as Attorney Coase and I litigate it in Middlesex Superior Court.
Okay, thank you. Any other questions, panel? All right, thank you both. As we march through 2021, the panel wishes you and yours a safe and healthy year. Thank you for your arguments.
Thank you.
With that, we're going to conclude our hearing today, and we wish to thank all of those who have made this possible, the folks in the clerk's office who created this platform for us, our IT staff, our law clerks, and our staff attorneys.